Hey guys, thanks so much for checking out Kitchen Court Cases, where we watch court in my kitchen. We have a great case tonight for you. After that great stream from Phil, just give me 1 second here as I get everything ready to go. This is one of my favorite judges. I think she may be a magistrate judge. I don't know. Her name is Judge Sylvia Holmes. She has quite a voice. I know that's Bluebell the dog. She has quite the voice. Hey guys, thanks so much for checking out Kitchen Court Cases, where we watch court in my kitchen. We have a great case tonight for you. After that great stream from Phil, just give me. Okay, there's some sort of playback. Hold on. Street judge. I don't know. Her name is Judge Sylvia. Okay, I think I fixed it. I'm sorry about that. I have so many windows open, you wouldn't even believe it. Anyways, now, oh, that's my sister at the door. I'm gonna get it going and then I'm gonna open the door for her. Here we go, guys.
Thumbs up so I know that my audio is coming through clearly for everyone. Okay, we're looking good. All right, we have several matters before us this afternoon. JC, have you got all the parties checked in?
Yes, all the parties that are here.
All right. When I'm looking at our docket, which cases did we have in which both parties appeared?
We had case ending in 1732. And we had 1649 and 1416.
Okay. All right. We're going to start with 22, 14, 16. We're going to go through our cases in which we have both parties being present. If we get to about 3 o'clock, 3:30, and we are still with our contested matters and we had not had any other parties appear, I may go ahead and take a moment to do the defaults. That way we don't make everyone sit around for all afternoon, but we will give parties a chance, their last best opportunity to try to arrive, recognizing that not everyone's good with Zoom. Okay. The case that we're going to begin with then will be cause 22001416. That's Mark Alpert versus Leanne LeBron, aka Leanne Hilton, and William Christopher Chris Harrison. On behalf of Mark Alpert.
Have me, Your Honor.
Good afternoon, sir.
Good afternoon.
Do I have someone here for Leanne LeBron, aka Leanne Hilton?
Yes, Your Honor, Leanne LeBron.
Good afternoon. Is there someone here for William?
I'm here for both of us, Your Honor.
Okay. Well, there's something happening with your speaker. That's gonna not be good. Ms. LeBron, do you have a power of attorney to appear on behalf of Mr. Harrison?
I don't, Your Honor.
All right. Well, we'll see. All right. Just some information for both parties being pro se for each side. In a civil lawsuit, the plaintiff will always bear the burden of proof. The likelihood is going to be more likely than not. That's the standard of proof applied here. Both sides have a chance to make a short opening statement. The defendant can always wait to make any statements until the plaintiff completely concludes with their case. This is always the case. We don't use that as harm against either party. It may just be, personal preference, or maybe a reason for that. In an opening statement, Mr. Alpert, when you begin, essentially you want to sum up from it very quickly. Are you seeking money or property or both? If you're seeking money, tell me the amount of money. Your Honor, I want $4,666 back, right? Tell me the amount of money you're seeking. Or if it's property, I want a Chevy 2005, VIN number such and such, like that. And then give me very quickly the underlying cause of action. Is this a breach of contract? Is this a subrogation from a collision? Is this an employment case? Okay. After that, opening statements, then we ask the plaintiff to provide or evidence. We would swear him in to testify in his own case. The defendant will always get a chance to ask questions of any witness put forth by the plaintiff. And that's similar to if the defendant puts forth any witnesses, the plaintiff will always get to ask questions of them. So for both sides, what I'd say is have paper and pen nearby. That way you can take notes of anything someone says that you either disagree with or want to ask questions about. Because when it's your turn, you'll need to be able to revisit those things. All right, Mr. Albert, why don't you tell me what the basis for this lawsuit is?
Yes, Your Honor. This was a landlord-tenant case. I was the landlord, and Leanne and Chris were the tenants. It started in November of 2021. I let her move in a couple weeks early without rent in good faith. Shortly after beginning the lease, I began getting all sorts of complaints about how things weren't working, needing repairs. I tried to remedy those and I lived in this property for 13 years. I was the last person occupying that place before the tenants moved in. I'm very, very proficient with what that house does and doesn't do. And I didn't get, my help wasn't well received, and the tenant still wished for repairs. So I tried to get one of my maintenance guys out there, and the tenant made it very difficult for us to gain access and to get the work done. And this kind of relationship got worse. At the end, prior to move out, Leanne just decided to short the rent by the amount of the deposit. And so in that case, that's where I have a bad faith claim. And my total claim is $13,470. And do I itemize that at this time?
Nope, just tell me the number again.
$13,470.
And that's based on a breach of contract, a damage claim,
It's
unpaid rent. What is the 13,470?
so triple, according to triple the deposit.
Why do you want triple the deposit, sir?
So bad faith claim 92,108, the deposit that she tried to use as last month's rent.
I'll review the statute, but I'm not familiar with that being against the tenant. I think it's bad faith against the landlord.
Well, it's against the landlord if we don't give a 30-day notice, but there is a provision where there's tenant bad faith, and it's stated in the lease.
Okay, you want treble damages for tenant bad faith.
2,050, so triple that, and then she broke a cooktop that parts and labor was $385.77, and there were, from non-payment of rent, there was $520 in late fees according to the contract. And she also never gave 30 days notice of move out, and she received an extension on September 1st that said if you don't sign, the new rent $4,100. So she owes November rent of $4,100.
Was she there in November?
She was not there in November. She vacated without giving keys. I don't know exactly what day she moved out.
All right. 13,470 from bad faith, trouble faces, some damages caused, and then unpaid rent. All right, can do. Ms. LeBron, would you like to make a statement now, or do you want to wait until after the plaintiff has given me all their evidence and information?
Your Honor, actually, I'd like to wait if that's possible.
Absolutely. Defendant can always wait till the plaintiff is completed. So defendant will wait to provide opening.
Thank you so much.
All right, Mr. Albert, you can go about presenting your case in one of two ways. You can start with testimony, which I'll swear you in, and you tell me the facts that you have personal knowledge of, or you can begin by presenting me with the evidence and we swear you in so that you can attest to that. Maybe kind of all in one here. Are you going to be the person providing the evidence today, or you have a witness that you're going to do that for you?
It's just me that's presenting the evidence.
All right, so please raise your right hand and state your name for the court.
Mark Alpert?
You understand you're now being sworn to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes,
Do you further swear and affirm that you are going to only provide me with your testimony, that there's no one outside the viewing of the camera who's there in the room with you or otherwise coaching you or providing you with information or answers?
yes.
Okay, go ahead. Thank you very much. All right. Mr. Albert, I'm going to ask you a few questions because I get the gist of the case, so it may be that I can steer you kind of quicker to the facts that would be relevant to meeting the burden for that, okay? But you can absolutely share with me more information. It's called developing the case. Court's empowered to ask you a few questions. So let me help see if you can establish for me the leasing information. How did you come to have the defendants be tenants in your property? Had you advertised this unit? Did you already know them? Were they neighbors?
She responded to either a sign or I had it on Zillow.
Okay, so you had listed property for rent, defendant responded.
Yes,
All right. Did the parties sign a contract?
yes.
Was that contract, what are the date that the contract began?
The term was from November 1st, 2021 to October 31st, 2022.
Did the lease have a provision about automatically renewing at the end of the lease?
Yes, provided neither party gives notice, which I gave notice
You gave notice to what?
of a terms for a lease extension.
Okay, but that was not signed.
It was signed by me.
But the tenant's got to
Oh.
accept it. So here's what I'm getting at. She never signed a renewal. So the lease on its own volition, would it automatically renew month to month, or does it come to an end and you have to kick her out?
The provision in the lease extension says what the month to month would be if there is no response.
Only in the lease she signed, not the extension, the original lease that was dated to start November 1st, 2021. Does that lease say what happens when you get to October 31st?
The lease does say that it continues to renew on a month to month.
Fantastic. Did you provide us with a copy of the lease in advance?
I did.
Let's take a look.
I might be able to give you a reference number.
I'm going to share my screen with you. I'd like you to tell me if you can recognize this document. Do you recognize this document?
I do.
Is this the lease that you're referring to?
Yes, it is.
Ms. LeBron, any objection to this being an accurate copy of the lease?
Yes, Your Honor, Mr. Alpert has changed the lease unilaterally multiple times and then resubmitted only the signature line. So there were multiple different iterations of the lease agreement, and I don't know which
Ms.
one this.
LeBron, look at this one right here and tell me if this is an accurate copy of the original lease that you signed. This one is dated Mark Alpert, Christopher, and Leanne. It says November 1st, October 31st, and it's 16 pages. We're going to look at all 16 together, okay? This one says automatic renewal 30 days before termination. It becomes month to month unless either party's terminated it. First page, I see at the bottom, there's initials on all of these.
Um,
Ms. LeBron, is this an accurate copy of the original 16-page lease that you signed with the plaintiff?
no, Your Honor.
Do you have, what is different about this lease than the one you signed?
So Mr. Alpert changed, there were some provisions that Mr. Alpert would remove certain things from the property, including a dryer and trash and debris and trees. And there was also, the rent was initially $3,000. But Mr. Alpert kept resending it to us. He said he was having issues with DocuSign, but he was taking that as an opportunity to change clauses that we never saw the clauses that were changed. Does that make sense? So he removed the things that he was supposed to do under the lease agreement, and then he changed the rent, and that happened in October of 2022. So this is not the original lease agreement.
Do you have a copy of your original lease agreement?
I did not submit that. I'm not sure because
That's
he
not
was,
my question, Ms. LeBron. Do you have a copy? Because he's giving me one. He says this is the original lease. So if you want to tell me that it's wrong or that isn't the one you signed originally, I need to see your proof of that.
yes, I understand, Your
Right?
Honor.
Because this one on its face meets the four burdens test to show me that it fits it. It's a lease, it's in writing, it's got signatures. It lays out the dates that he told me. So if you want to contradict it, you need to have your copy ready to go. So start looking for it.
Yes, Your Honor, thank you.
Okay, because nothing about this tells me that this is a valid lease. It's properly attested to, it's signed by everyone, it says the things that he says it says.
Yes, Your Honor, it's just the caveat that he made those changes, but otherwise, that was the lease agreement.
Okay, so he signed a lease agreement, Mr. Alpert. Under that lease agreement, the rent is listed as $30.50.
Correct, Your Honor.
Okay. All right. Did the defendants move in on or about November 1st, 2021?
Specifically, more like the 17th of October. I allowed an early move-in.
Okay. Did they pay rent on November 1st?
One moment. Yes,
Okay. Did there come a time when they did not pay rent as required one time per the lease?
yes.
When was that?
January was paid on the 10th. The April was paid by somebody else, a Sherwin Furtivar on the
Hey,
3rd.
Mr. Alpert, in January of what year?
Oh, so that would be 2022.
Okay, so the rent was due January 1st, 2022. Defendant failed to pay it. Did they eventually pay the January rent?
Yes,
When did they pay that?
on the 10th.
All right. And did you take any active action against them at that time?
I don't believe so.
All right.
I try to give a freebie, not
Good.
knowing.
All right, that's January 2022. Did there come a point when the defendant stopped paying rent?
Do you want me to differentiate between that and paying late?
Yeah, you told me that you're here because they didn't pay their last month. They let her deposit lie. So
Correct,
if she was late in January, but that you didn't take any action and she then caught it up on the 10th,
Yes,
because you told me that you were seeking bad faith and late fees. So
yes.
how did you come to get to $13,470?
Okay.
Did they pay a deposit when they moved in?
Paid 2,050 security deposit and a $300 pet deposit.
Is the pet deposit a true deposit? Did they get it back or was it one of these non-refundable deposits?
No, this is a refundable one, and in the lease, under that section, it stated that it's an addition to security deposit.
Sure, that's fine. I see both of those. Okay, so 2,050 for deposit, 3,000 for pet, so a whole $1,000 less than the monthly rent.
Correct, and so then that was the defendant's last payment to me was for $1,000. And then followed up by
When did they pay that $1,000?
maybe the 3rd of October. I'm looking that up.
Of what year?
I'm sorry, of 2022.
All right, so the lease was supposed to end October 31st. On October 1st, the defendant paid you $1,000,
Yes,
but not 3,050.
correct.
So they were short 2,050. Did the defendant give you any indication about why they only paid $1,000?
Yes, on my exhibit 1, page 1, an email was sent from Leanne to me stating that because she doesn't trust me, that she's just paying $1,000 via Zelle, and and that the rest of the rent is the deposit. Is from the deposit.
All
And
right,
then
let me
she
share
asked
it to my
about,
screen. And tell me if you recognize this email. Do you recognize this email, sir?
yes, I do, Your Honor.
Is this the email you're referring to, or should I go back in time? Is this the first one in the chain? This
Oh,
one's
you're
a
correct.
page later.
You're correct.
Now, this is October 4th. Rent was due the 1st of October, correct?
Correct.
And had you received email communications from this address, Casa Leanne TX, before?
Yes.
Whose email address is that?
I believe that's Leanne's, the defendant.
Had you communicated with her at that email address prior to this?
Yes,
Okay, and are you this person, Albert Mark Gmail?
I am.
All right. It's non-renewal. All right, so she says, we don't want to stay, we're leaving.
But just a time for me to clarify that?
No, I'm reading it.
Okay.
It's clear as day. We don't want to be here anymore. We intend to vacate by the end of the lease. So she plans to be at the end of the month. Cool. All right. So she says, we're leaving at end of lease, which per the lease I've been seeing would be the end of that month. As for rent, I was in the middle of paying it yesterday when I got your emails. You have a limit of $1,000 on Zelle as we intend to vacate. You've been less than honest, and I suspect you want to take my deposit any way you can keep it. Ooh. Eek. You cannot do that, Miss LeBron. I'll just advise that right now. That's improper under Texas law. You're never allowed to let the deposit stand for the last month's rent. We'll get into all the details of it. I'm just, for anyone who's listening, FYI, you can't do that. Not ever. Okay. But you're right. She says it in an email, so I have no reason to believe that that's not the reason they did it. Okay. We provided the notice and suspect there's no need to communicate. Well, don't count on that. This will be my last communication. I don't want to hear from you again. Well, you're going to have to because you're still there in possession. What if a fire broke out? Right? We don't want to be disturbed. Forwarding address. Then she gives an address. Great. Great. And provides a forwarding address. The issue in this one is that she says she's going to let you use the deposit for her last month's rent. You can't do that. That's just flat out not proper in Texas. Okay. But she does give notice that she's ending it. I don't want to be here. Had a horrible experience. Here's how you can send me my money when we're done. Because she sends her pet deposit back. Okay. Forward address for the pet deposit. All right. All right. Ms. Liberal, do you recognize this email?
Yes, Your Honor.
Is this an accurate copy of an email that you sent to the plaintiff?
Yes, Your Honor.
Okay, fantastic. All right, Mr. Alpert, how about the response? Do I need to, would you like me to look at this? Does this provide more information?
In terms of my response to that email,
Yeah.
well, she asked that I don't bother her anymore, and I felt very legally at risk. I didn't contact her anymore. She really had me worried that I could make trouble by not abiding by her request for privacy, honestly.
Okay. All right. So she's paid $1,000. You have no communications beyond this. What happens at the end of October?
I checked on the property at the end of the month. I had someone check on the property. I'm out of state, and the door was open and the place was vacated. And it wasn't left in the condition that she received it in. And so then we began making repairs and
Mr. Alpert, is that agent who went to check on the unit with you here today to act as a witness?
no, I have in terms of supporting evidence, I have some emails. I'm sorry, text messages that were submitted to the court.
They may not be admissible, Mr. Alpert. So generally, the best evidence will be the person who has honest testimony about it. Not otherwise, I can't cross-examine that person and ask them about the veracity of their testimony. An email is at best a historical document that will have a limited use for me.
I understand.
All right.
And in my request, in my number, there's really not a whole lot. about the repairs. I'm eating that pretty much.
All right. So you sent an agent out, found that the property was empty. Did you get the keys back from the defendants?
No. No, Your Honor.
What steps did you take after you found the unit had been vacated?
I secured the premises and I just made all the repairs and leased it out again.
How did you communicate to the defendant?
I had no more communication with the tenant at her request.
Did you ever itemize or send them a letter that says they're not getting back their deposit?
I didn't, because she said use my deposit. So the only thing that I haven't addressed, and I understand that's my negligence, is the $300.
What communications did you have with the defendant other than suing her?
I didn't have any I stopped having communication with her when I received that request. I felt as a man.
No, don't bring in gender, Mr. Albert. You're a landlord. You're supposed to understand the laws in which you're regulated. You have a contract for money, and someone says, "Don't bother me anymore," and they owe you money. That's a legal fiction. You're a landlord. You absolutely have obligations and responsibilities to the property and your tenant. One
Yes.
of those is that when they move out of the summation of the lease, you have an obligation to send them a refund, either an itemization or a check
Right.
back within 30 days of them vacating. She gave you an address. Did
Yeah.
you ever tell her, "I'm keeping all your money because you damaged it"?
I am at fault on the $300 pet deposit. But I don't believe that I have any. I believe she's already spent, as she clearly said in writing. I don't know why I would need a disposition of her deposit on something she's saying she's using for rent, even though she's
Because
not
she's-
allowed to.
You're not allowed to, y'all. Here's the thing
Oh.
that I got for both parts here. You can't come to court and want to enforce the law very specifically when you've not followed it very specifically. Right? Like, you want me to find her treble damages for not doing it right when you didn't do it right either.
But the bad faith started when
Bad
she
faith-
created the bad faith.
Her bad faith is for you to win out on, but if you act in bad faith, you're equal then.
I understand.
And you used a TAR lease. Did you use a real estate agent to help you create that lease?
I'm a broker and it's my account.
And then you 100%, Mr. Alpert, now you even have more obligation and duty because the lease is real clear. And Texas law is very landlord friendly so long as you follow it. Right? Okay. So she left you high and dry for the last month of rent. She was current up until then. Is that what I'm hearing?
She was never current. There was a
A
small
persistent
down.
late fee, and because you applied the rent to that, she was constantly behind. She never got it zeroed out again.
Well, there was more than that. She also decided to deduct a plumber's bill without letting my plumber in. And so she subtracted something like $120 from rent, and that wasn't allowed. And so she's always been behind. And I believe I can get you the document number.
Okay, so there were late fees that accrued throughout the entire lease, pretty much. But the big deficit was that in October, rather than give you $3,000, she gave you $1,000 and said, "Let my deposit hold for it." But when you got to look at it, even we're ignoring the fact that you can't do that legally. If we're looking at just the summation, did you get enough money at the end of the day? When she moved out, had all the utilities been made current and paid by the defendant?
No.
Were there utility bills that were stuck
Oh,
that you were left with as a result of her use?
I'm sorry, I might have not heard you. You said utility bills?
Correct.
I was not in possession of any utility bills, so she was good there.
Okay, so good on that. So what was left behind then was the rent for the last part of October, that $2,050 or $2,000 for rent. And then on October 1st, what was the outstanding balance for late fees that had accrued? What was the deficiency that you showed in your ledger?
Oh, that was one of the last evidence pieces I put in. It's October 4th,
Let's
I
see.
believe. Do you see that in the evidence? The email to it was page 2.
We had plaintiff's exhibits. We got 128 items.
I know, it's one of the last ones, like one of the last 4 or 5.
In the one, okay, let me take a look. Not a problem. We did
I'm
lots of
sorry.
things, y'all. So you're fine with giving us a lot of evidence. Let's see if I can locate this one. This looks. Is this a lot of is this a text message chain between the parties?
The exhibit 2 is an email. Or page 2.
Hmm.
So I got it.
These are screenshots because then y'all say this is too much text. Let's go to email. Just going straight past it. And there's something from the Real Estate Equity Commission, Real Estate TREC. Another thing, TREC, California.
Are you looking for the document?
Yeah, I'm trying to find if there's a ledger outstanding here where you explain like what the balance was at that point. This is not it, so this is something different.
There was a tar form that I sent just this morning, and it is notice of breach of lease.
You submitted that to us this morning?
I did, and I got confirmation that it was submitted.
All right, JC, if you see that before me and you wanna let me know where it's at in the list, I'll get to it quicker. I see the late notice on October.
Yeah. What, October 4th or something?
Yeah. I
Yeah,
see
that one has an amount that's due that wasn't honored. That's the one.
Did you keep a ledger?
I did it. I mean, I got the history of all that was paid. I mean, it's to me, I don't have a client on this case. This is my own rent. And I don't.
Right, but I just, it'd be easier if you had a ledger that showed, rent due, they pay, utilities this, and then here's the late fee showing like what is the balance outstanding on October 1st. So,
So you would like me to show you more detail than what it says in that notice of late rent?
yeah, because
or-
it just says that that's not what I see. What I see is that we're increasing the rent next month because you haven't signed a renewal.
Oh, no, that was the extension. Okay. Yeah, I just sent it this morning.
JC, have you seen that come through?
Let me look at what was sent this morning.
All right, it's a TAR notice from the Texas Realtors.
It is.
Albert? I think
It
this
is.
might be it. All right, you recognize this document?
Yes,
Mr. Albert,
Yes,
is this the late notice you're referring to?
it is. Thank you.
Okay, so this is dated October 4th. It says to William Harrison, Leanne LeBron, late notice, 120 for May 19th, a late notice as unpaid rent, $50 for June, and $20.50 for October. Carrier breach, at that point, it was 2310. Okay.
Together,
Nothing else.
which is
Signed
very
October 4th.
cool. Thank you,
Via
Biggin, for
email.
that.
All right, Ms. LeBron, you recognize this document?
Everyone's telling us about it.
Should be interesting.
It should be interesting. We've got a throuple.
Okay, I apologize because I legitimately have 100 tabs open and sometimes they just start playing. So, I will fix it now. We didn't miss anything. I paused it, by the way.
I have not seen that, Your Honor.
Okay. It says it was emailed on the 4th to these two addresses here. All right. Court would take this in as exhibit 2. This would be the plaintiff's late notice. Of particular interest for me is this statement of fees here, like how he's coming to that number. On October 1st, he says it was 2310, of which 2050 was rent. And the rest was late fees, 170 from before. Okay. All right. How about the broken cooktop? Are you seeking money for that one, Mr. Albert?
I am, I have. I'm sorry, I did give you a ton of pages, not knowing where we were gonna go with this today, but I have an Amazon, it's 87, number 87, and 88 and 89 state. I ordered it off of Amazon. It's identical to the brand new one I put in before she moved in. And
You have
then,
proof that it needed to be replaced.
it was replaced and I
know,
I
Mr.
have to show
Albert,
you.
Mr. Albert,
I'll
I
have
have
to
no
do
doubt,
proof.
I have no doubt that it was replaced. Do you have
Okay.
proof that it needed to be replaced?
Oh, well, I guess that's where I'm in trouble because my worker told me it was correct. So I understand. I've learned my lesson. I don't have any way of proving that to you.
Okay, but yeah, all right, we'll leave that one out then.
I'm sorry.
No, that's okay. I don't doubt that you did replace it. It's the question is did it have to be replaced because it was so damaged beyond ordinary wear and tear or beyond the ability to be repaired and kept in place? So there's different ways to get that, but that's okay.
I understand.
We're getting down, so it's the rent, the late fees, and then bad faith for that. Okay, Mr. Albert, what section of the property code statute are you looking into for tenant bad faith?
Okay. It stated as property code 92.108. But it's also stated in the lease, maybe in more specifics. Under paragraph 10, there's like ABC and then there's 1. This is on page 4 of the lease agreement. A tenant may not withhold payment of any portion of last month's rent on grounds of the security deposit as security for unpaid rent. Bad faith, this is number 2, violations of 92.108 may subject a tenant to liability up to 3 times the rent wrongfully withheld and the landlord's reasonable attorney's fees.
And then number 3, the code does not obligate the landlord to return or account until the tenant gives a written statement with an address. So she did that.
Yeah. I admitted that I should have done something with that 300. I mean, I didn't do a perfect job. I get it.
$92,058 remedy for tenant violation. If the tenant withholds rent, causes repairs, or makes deductions in violation of the section, landlord can recover actual damages from the tenant. This is just about repairs. Said that she did that once, but this is about withholding the deposit. And that's under a different section. $108 does make a presumption that a tenant who violates this section for withholding the last month's rent is presumed to have acted in bad faith. A tenant who in bad faith violates the section is liable to an amount equal to 3 times the amount wrongfully withheld plus reasonable attorney's fees. Well, we don't have any reasonable fees. 92-109 is about the landlord who in bad faith holds on to it as equal to trouble. So essentially we've got bad faith on both sides. But we're really being sticky to it. But she did leave you without rent for the full month, and she left you with a deposit. And after that, you incurred damages because you said you had to replace the cooktop. Well, we don't have any information about that. Mm. Mr. Albert, you told me it was 13,470. So if the bad faith was 2050,
Oh, it's triple.
yeah, but I triple it, that's only 6,150.
I'm sorry. There was one thing I didn't mention yet. Well, there's a couple things. I believe where this is going is that even though she didn't give 30 days notice, where it sounds like the court is just deeming this to be dead at the end of October, in which case I wouldn't be able to ask for the 4,100 November rent. So I understand that that's probably where we're going. So we'd be subtracting that amount.
That's correct.
But there was a key box withdrawal provision in the lease. And when a tenant says they want to be left alone and they won't let me market it for 30 days, it is stated prior to moving in on the lease that there's a cost to do that. So I'm asking for relief based on her wanting me to leave her alone and not be able to market or get the property, further along to make money again.
Have you relet that property?
I have.
When did the new tenant move in?
Earlier this month. There's been several months.
Mr. Albert, did you make any attempts to show the property in the month of October?
No, not while she was there. She also has a big dog. That just doesn't sound like a good idea for me. When she asks to be left alone, and I don't leave her alone.
Mr. Albert, I'm not persuaded by that. Right? You're a property owner. If the tenant doesn't want you there and you're concerned about your property, you always have superior rights. Always. But a knock on the door, you can go in and inspect your property. Reasonable notice is up to interpretation. That's why you're required to put the keyless deadbolt doors so that you can't just walk in on your tenant's showery like a hotel. But other than that, you can do anything you want with your land except take her out without cause, right? So I'm
Right.
not persuaded because she sent you an email that said, you can keep my deposit and don't bother me, that you felt you couldn't go and utilize your property, especially since you had an agent who you did send over there to check on it. So not persuaded by that. She absolutely should not have made you use the deposit for the last month's rent. Clear cut. That's a violation of the law. She can't do it. It's not only in the law, it's in your lease. It's unavoidable that that's a part of the clause. That is a bad faith allegation. It's been proven, right? So now I'd like to hear from Ms. LeBron, because what I'm seeing is that of the things I've heard, I'm not hearing any real evidence of damages here. What I'm hearing evidence of is that, yes, she did not pay her last month's rent in full. She absolutely made it clear as to why she was not doing that. She wanted you to use the deposit. That's a violation of both the lease and the law, which gives a presumption of bad faith. So, Ms. LeBron, thank you for your patience with us, but I would like your response to these allegations now. Plaintiff has met their burden to at least a certain extent within their lawsuit. So, would you like to make an opening statement first, or would you like to get into testimony? It's your choice. You can do both.
Probably go ahead and swear me in, Your Honor, because I may cross over since I don't know all of the.
Okay. All right, so just raise your right hand and state your name for court.
Leanne LeBron.
You understand you're now being sworn to tell the truth, the whole truth, and nothing but the truth under penalty of perjury.
Yes, Your Honor.
Do you further swear and affirm that there's no one in the room outside the view of the camera who's coaching you or texting you or otherwise giving you information or answers?
Yes, Your Honor.
Okay, fantastic. All right. Ms. LeBron, so the plaintiff here has provided me with some information that indicates that there was a lease between the parties, that lease began a little bit before November of 2021, and that it culminated by its own terms at the end of October 2022, that you and your co-defendant, Mr. Harrison, did indeed move out by the end of that month. And he's alleging that because you did not pay the last month's rent in full, that instead you said use the deposit, that is per statute of bad faith, and he is seeking treble damages as a result of that.
Yes, Your Honor, I understand that. It differs actually from his pleadings. So I just want to notate that in Mr. Alpert's pleadings, he asked for approximately $2,000. And I am not aware of any pleadings amending that. So I just wanted to note that.
How about the underlying fact pattern? Did you
Yeah.
send him that email and tell him to use your deposit?
So, Your Honor, am I able to kind of give a statement? Because there's a lot that is very, very untrue here. Is it possible to my opening?
Ms. LeBron, that's what I asked you again with. And besides which, it sounds like you want to give testimony, which is not really an opening. The question I have is just that one simple fact, and then you can give me all the other story. Is that true? The email you sent him, did you tell him to use your deposit for the last month's rent?
Yes, Your Honor. I sent that email at the end of October, I'm so sorry, beginning of October.
Let's stick to the real relevant stories of this, right? Because have you filed a counterclaim?
Yes, Your Honor.
And what is your counterclaim for?
So my counterclaim, I asked for $16,811.63. Yes, Your Honor. So it was due to first of all, DTPA claims. The home was not as Mr. Alpert represented or marketed the home. It didn't have the features or the standards or maintenance. So the breakdown of that, and that was also for repairs. Throughout the duration of the lease, the entirety of the lease, I did not have access to the majority of the home or basic features such as electricity. The bathroom flooded the kitchen every time you used it. There were multiple issues with the home. I have repair costs that I paid that Mr. Alpert approved. I also have the deposits that I paid. There's harassment, emotional distress, and then Mr. Alpert. So on October 1st, I was visited by the city of Austin, Your Honor, the code department who condemned the home and told Mr. Alpert that he was not able to rent the home anymore. So during this time, I'm trying to move out. I'm paying the last month's rent. I began being contacted by the city of Austin code department and harassed by Mr. Alpert at the same time. I wasn't sure what to do in that moment. So I sent that email saying, take the last $2,050. I expect.
So you're admitting it's true, the thing that I asked you. Did you send an email and tell him to use your deposit for 2/3 of the last month's rent? Yes. Great. Now, your reason is that because the home was being condemned, in your words?
Yes, the city of Austin. Yes, Your Honor.
That's a very specific kind of legal allegation. Do you have paperwork that tells me that home is prevented from being relet?
Yes, Your Honor. I submitted it actually with my filing. When I filed my counterclaim, I attached the 6 pages from the city of Austin listing the multiple code violations and the property being unsafe, fire hazard, multiple issues with the property.
Miss LeBron, telling me all of that is not going to persuade me. Let me see what the county actually gave you, the city said, right? Because they're the authoritative version of this, not after the fact when he sued you. So let me take a look. What is the name of your exhibit that you submitted to us?
It was attached to my pleading, Your Honor. When I filed the counterclaim, it was attached.
What was the name of the attachment? Because I see like 12 exhibits from you.
Oh, Your Honor, it was when I filed my counterclaim. It was attached to my counterclaim.
I know that, but they're all listed as defendant's exhibits. So do you know what you called it?
No, I don't, Your Honor.
Is it
I
a
don't.
video? Is it a document? Because I mean, there's lots of things here that are marked defendant's exhibit. Lots and lots and lots of them. I want to get to the item that you're trying to direct me to quickly.
Let me go. Give me a second, Your Honor, because I filed
For
that.
anyone observing, if you're coming to court, label your exhibits. Right when you submit them. Like if you come to court, you need to know that this is a copy of my bill. This is a photo dated this day. But if you say I attached it, y'all, there are 400 attachments to this case alone. I want to get it quickly for you, Ms. LeBron. What's the document?
And I don't know, Your Honor. I submitted it. Once again, I submitted it with my counterclaim and it was directly. So do you have the counterclaim itself?
Yes, we have everything that's been submitted.
Okay, so it was directly with the counterclaim and it was a 6-page document.
The way y'all attach it is not the way it gets brought into the system though, right? We have to attach it as a legal document, which is an exhibit. So it's not all one big thing. It's your petition, your counterclaim, and the exhibits to the side.
I brought it in.
Maybe if you are listening along and you can quickly find her document for JC, that would be helpful.
Yes,
I
ma'am.
want to see this city violation. Here we go.
This one is dated November 17th, the City of Austin violation report. It's an 8-page document.
Thank you. I see this. All right.
And I apologize, Your Honor. I had brought it into the JP3 when I filed my counterclaim, so I wasn't sure.
All right. This is Ms. LeBron. Do you recognize this document?
One moment, Your Honor. Yes, I do. And I just want to correct, it's dated October 7th, the actual document.
So this is 6 days after your email to him.
Yes, Your Honor. This was after they came out to visit.
Okay. All right. This is an 8-page document. I'm just going to thumb through it. That is not a part of the document, right? So like this is something completely unrelated. This is the document. At the end of it looks like things that the defendant created and tacked on. So we will not be looking at page 6, 7, or 8. We'll be looking at the first bit. Okay. I see a date at the top, says City of Austin Code Department to a Mark David Alpert. Mr. Alpert, do you recognize this document?
I was on mute. Yes, Your Honor.
Is this a code compliance letter that you received from the City of Austin?
It is, Your Honor.
Smoke alarms need to be installed. Carbon monoxide detector. Smoke alarm on the first floor. $30 to fix a kitchen cabinet sink. This is definitely a concerning one here about the exterior door moving. Right, these I can say, these are niceties. This is a security issue. People still use telephones.
I think there was hanging wires, Your Honor. They were just hanging.
I saw it. Mr. Ron, I saw it. Just certain things stand out as a legal issue as opposed to a nicety. And some of these are niceties, but not necessarily a health or safety issue under the code, right? So the city can highlight all kind of deficiencies. As the judge in this kind of case, I'm looking for very specific types of things. So there are at least 2 that I see that would rise to a, hey, that has to be taken care of. Garage window glass should be fixed. Like this is 100%. I mean, okay. If it's a leak, you got to find a leak. But the fact that it's got cracks and peeling paint, that's just old. That doesn't have to be fixed. Same thing. Like, unless this is proof that nothing is going to fall apart, it's just old and it's got cracks. That's going to happen. Same thing. Gutter in the soffit, not a thing that's going to repair, but action under health or safety code for property code reasons. All right. Now, this is a dated letter, October 7th. Ms. LeBron, had you made a written request for repair for any of the items that were noted in this report prior to October 7th?
Yes, Your Honor.
When did you make those repair requests?
Starting in October of 2021, and this was October of 2022, so a year prior.
What items had you sought repair for?
Yes, Your Honor, that list is long. So, is it possible for me to give any testimony now, or would you just like me to answer that question?
Just answer the question, because that is testimony. So if you said that you noticed these problems in October of 2021, What did you ask him to repair?
So, Your Honor, the outlets in the home did not work. There were one or two that worked throughout the home. They did not work. I would press the GFCI or GFI button, and a couple of them would work some of the time.
Okay, electrical outlets, that's the one you asked for. What else?
The electrical outlets where the wires were hanging out of the wall and the phone outlets. The windows, the issue with the windows wasn't a cosmetic issue. These windows, there were huge gaps. The rooms were completely freezing. Water was coming into the home, both from the front of the house and each of the rooms. The rooms were not usable for my children because they were freezing in these rooms during the winter.
Ms. LeBron, outlets, the wires, the windows, what else did you make a written repair request about?
So I actually submitted evidence with my written repair requests, and I can pull those up, but there were garage doors. The garage doors were not, functional at all the entire time. There was the shower upstairs. If you tried to use it, it flooded the kitchen. And so we didn't have access to the shower upstairs. Outlets were sparking and frying anything that you tried to plug into them.
All right.
There were multiple, so
Okay, Ms. LeBron, did you provide us with proof of these written repair requests?
yes, Your Honor, I did.
What's the earliest one you submitted to us?
I know that there are several from February, but we had been communicating via text prior to that. Sorry, I'm trying to go back to I just lost my notes. I'm so sorry, Your Honor. I know that there were several submitted from February. We had been communicating since October on the repair requests. Let me go to, I'm just toggling here, and then I apologize, Your Honor. So by the time we had moved to email, I had actually had to really try to work with Mr. Alpert because he was harassing us all hours of the day and night. And so I was trying to get the repairs done, but not be harassed. And so if you look, it's titled Mark February email. I talk about the repairs. He had emailed me at 1:48 in the morning. And I talk about some of the repairs in the Mark February email.
All right, Ms. LeBron, let me show you the document you asked me to pull up. This is what I have here. This is 5 pages. I'm gonna zoom out so you can see top to bottom. Is this the email chain that you're referring to?
Yes, Your Honor, there's an additional one. And let me just, if you'll scroll up, yes, there's that email, Your Honor. And then there's also an additional one that's along those same lines, and
Is that earlier than February 2nd or after this one?
it was after.
Okay, let's take a look at the earliest one because timeliness is what we're trying to get to here. So here's one that's dated from Leanne H., that Casa Leanne TX address that he identified in the plaintiff's first case. So
Yes,
this
Your
is your address. You do use it.
Yes, Your Honor.
Great. So from that address, you emailed him at the same one we saw before, and you CC'd Mr. Harrison at the same address. So we're all using the same email addresses. There's no reason to think they weren't working for the plaintiffs if they're working in yours.
Yes, Your Honor.
What are we on? Lisa at this address. We disagree, which means that this is a continuation of a conversation from something else. But we disagree. Please review the lease that states 2-day grace period in bold, but can resume further discussions next week. I'm assuming this is about paying late.
Yes, he would email every single month claiming that the rent was late, but the rent had been paid and deposited. On this, the lease actually does provide a 2-day grace period, but every month we got a notice that the rent was late despite it not being late.
I mean, I would argue, I'm not gonna care. That's not relevant to whether or not you can prove damages. So I'll just leave that with y'all. But
Well, I had deposited it, Your Honor, and so I would tell him it's in Comerica, and he'd be like, "Oh, okay."
thanks for providing your new address in Venmo. We'll take care of that and respond more as available. We need approved to provide you again list of items needed repair. I'm happy to. So this responds that there had been a previous request. Because if I need to do it again, I will. I believe kindly reporting those items to you to be the source of frustration I'm receiving. Happy to review together, but things including but not limited to garage doors and shower not ported to the kitchen downstairs. I would agree. The garage doors, technically that's considered a vanity item and they don't ever have to fix it. Get into an argument about that one, but You can open it yourself, then you've got a door. Shower according to the kitchen, that's a concerning one, right? Like that's right there. Other issues such as cameras and smart home market that don't actually exist. Well, you're right. It's not in the lease, you're not covered. This is true. Like when you move to an apartment complex and they highlight that they've got a great pool, if they cover the pool in and get rid of it, you don't get out of your lease and you don't get any money back because you're paid for the 4 walls and a roof, which is why I'm concerned about the exterior premises part, right? But all the rest of it is generally considered cosmetic and not required for the actual benefit of the bargain. Air conditioning isn't even covered by Texas law. Air conditioning isn't required. Heat's not even required by Texas law. City of Austin ordinance requires it, but there are parts of the county where you're SOL. So just be aware of that, y'all. I'm wondering when you'll remove the dryer, the wood pile, and the trash and brush from the property stated in the lease. I'm sure we can work that out, but it's been several months. Loss of use potentially. As it relates to the deposits, I understand the pet deposit was included in the second increased deposit amount provided as paid price. I'm a little confused about that. 752. So this is in response to this one. So this will help inform me a little bit about it. Chris wants to communicate and work directly with me on all things. All right, so talk to me, don't talk to Chris. There's never been a grace period or property code giving you that. I would agree with that.
It's actually in the lease, Your Honor, and he cited it.
I agree the property code doesn't. And generally, I don't know what your lease says, but if it's TAR lease, generally what it says is that rent is due the 1st. They don't charge a late fee until the 3rd. But it's still late if you don't pay it on the 1st. The fact that there's no fee charged on the 2nd doesn't mean it's a grace period. You're still late.
Right, Your Honor, we were arguing.
It's a matter of can they charge a fee for it. But
Right, we were arguing about the fee, Your Honor.
and that's fine. But in terms of is it late or not, if it's not there on 1st, it's late. Whether they can charge you a fee is a different question. Okay. Not relevant to y'all's case anyway. But I mean, I can see that that's a dispute y'all are having. I'll just advise you that no. Shower function that you believe to be in need of repair does not functioning, resulting in water damage at the kitchen. There's no other items you referenced that warrant a repair, in my opinion. Overloading circuits requires the occupant to reset the breakers. No, Mr. Albert, you're just asking for a problem with this. If a fire happens, oof, I would hate for that to be the final thing you said in an email. Windows are not broken, front door is not broken, so we disagreed about that. Well, that's a question of fact for the parties. Last occupant was there 13 years. Yeah, who cares? You know, you can have a great marriage with someone for 20 years and have another one that lasts only 2 weeks. So whether someone else enjoyed it, not really relevant, right? Especially if the code is saying that there's a bunch of things that are outdated and need to be updated. All right, people have 2 different ideas. I got this 148 AU. Maybe he's just busy. You don't have to respond because he responds in the middle of the night. Rent's due with a grace period. Oh, I don't care. She asked again, when are you going to get rid of the stuff that's sitting out in the yard? It's been difficult working out an easy way to transact your rent. It's been late 2 months consecutively. It's late again for February. So this is him. And that's where y'all keep getting into this grace period thing. And just to be fair, him reminding you that rent is due is not harassing. He's a creditor. He wants his money. He's allowed to do so.
No, Your Honor, that wasn't what I deemed as harassment.
All right.
Mr. Alpert moved in January.
So, real quick, Ms. Liberon, though, for the purposes of what I'm reviewing this email for, things you requested: garage doors, showers in the kitchen, missing cameras and smart home items, outdoor lights that can't be turned off, and then trash outside. So we've got garage doors, upstairs bathroom flooding,
Outlets.
okay, outdoor lights can't turn off. Missing cameras and smart home items. Dryer, wood pile, and trash outside.
Yes, Your Honor.
What kind of dryer? Was it like a washing machine and dryer?
It was an old dryer, Your Honor, that he was going to remove, and it just stayed for the entire year. I also referenced the outlets, the fridge and the stove as well. They were all smart compatible, and Mr. Alpert, the fridge and freezer, He said they had to be on a timer to be turned off at a certain time in the middle of the night so that they didn't freeze over. But the smart home never worked, so that could never happen, and so the fridge and freezer never worked properly either. Mr. Alpert is some kind of a maintenance man himself, and he made certain things and wiring to this home that made it function in a certain way. And so for him, it was perfectly fine that he was resetting the refrigerator at 3 a.m. versus whatever wiring and contraptions he was using. But I didn't have access to, the fridge and freezer and things like that while living there because I am not MacGyver. I don't know what he was doing with the smart home that he marketed didn't exist when I moved in. So I don't know what he was doing or how he had things set up. It was kind of things were rigged in a way throughout the home. Wiring hanging, he had created various things throughout the home, in the closet, on the exterior.
All right, Mr. Albert, do you recognize this email chain? I'll show my screen again. Did you recognize this email chain between you and the defendant, Ms. LeBron?
I don't recognize the February 2nd. I had some February 6th. I do recollect some of
This
this
email?
language.
It says that you
This-
sent this February 2nd at 7:37 in the morning.
Yeah,
So no
I
reason to
just-
disbelieve that.
no, and I'm not asking, I'm just saying that that's not coming up on my evidence, so, but let's go with it. I mean,
Okay. All right,
the,
Ms. LeBron,
oh,
were the garage doors ever repaired?
No, Your Honor.
Was the upstairs bathroom fixed?
No, Your Honor.
Were any attempts to repair it made by the plaintiff?
The upstairs shower, yes. Mr. Alpert would find guys off of Craigslist and send them to the home where me and my children lived, and they were random people. There were more than 12 no-shows of his contractors that I took time off of work, that I sat at the home and waited more than 12 times in the first couple of months of the lease agreement. So he was finding these guys on Craigslist. And so he found this guy on Craigslist. He comes out to the home. Your Honor, he brought a kitchen sink to replace the shower head in the shower. And he could not figure out why he couldn't make it work. And he came out 2 different times to do that, Your Honor.
Did the bathroom ever get fixed?
No,
Okay, you said that they attempted it and they never fixed it. How about the outdoor lights? Were you ever able to turn those off?
no, Your Honor. I paid for electricity for a solid year on those lights. And one of the neighbors messaged me and said, can you please turn off the lights? And I said, I would love to. I said, I would love to.
Did you ever find, were the cameras ever installed?
No, none of the smart home features, cameras, ports, controls for the fridge, stove, lights, none of it.
All right. Was the dryer, the wood pile, or the trash removed from outside?
No, Your Honor.
Did the fridge and the freezer outlets ever get fixed so that they worked properly?
No, Your Honor, the outlets never got fixed. They sparked the entire time and the other ones didn't work. And then there were hanging wires out of the remaining ones.
All right. Did you, of your own cost and out-of-pocket monies, have to spend money to repair any of these items?
I repaired a flood in the downstairs bathroom due to lack of maintenance, and I had a text message from Mr. Albert. So the same guy with the kitchen sink for the shower, he sent that guy out 3 different times. And so he came out 2 times and he said he couldn't fix it. And he was very upset with Mr. Alpert, expressing that Mr. Alpert was acting crazy and saying that he couldn't fix this, but he was going to try.
Ms. LeBron,
So he came out to the home
did
and,
you get it fixed yourself?
well, Mr. Alpert asked me to. He texted me and said, do you want to call a plumber? And I said, sure. I called the plumber. I went to bed. The plumber came in the morning to fix it. And this was a flood due to lack of maintenance. The seal had broken. The toilet was broken on the bottom.
Did
So
you hire the plumber?
Mr. Alpert asked me to. I called the plumber. The plumber came out. He fixed it. And then with no notice, Mr. Alpert sent the same kitchen sink guy after it was repaired and threatened to charge me with a trip charge. After he asked me to call somebody and get it fixed and said his guy couldn't fix it.
Ms. LeBron,
Yes.
who did you hire to fix the sink downstairs?
I think it was Steve's Plumbing. I can look, Your Honor. I submitted the receipt in evidence.
That's what I'm trying to get to. What's the name of the company? What did you actually spend on it? All the rest of this, I believe you, right? I'm trying to get to whether or not you're getting any money back from this. All right, so you said you sent us a receipt.
Yes, Your Honor, I'm
See if we
looking
can
for that
find
right
that. I
now.
see Mark Plumbing receipt. Maybe that's it. Email chain. I guess that's a receipt. Austin Select Plumbing.
Yes, Your Honor. It was a like square payment that I made.
All right, I'm gonna share my screen. Do you recognize this, Ms. LeBron?
Yes, Your Honor.
And what is this?
That is one of several receipts that I provided to Mr. Alpert for the plumbing repair that he requested.
Did you hire more than one company?
No, but they provided two different statements and I sent them both to them. I sent them both to Mark and this was the one that was on the thread.
Did you pay your own out-of-pocket expenses to cover this bill?
Yes, Your Honor.
How much money did you spend in total to have that plumbing repair made?
$120.
Okay. Mr. Albert, do you recognize this text message chain? Or this screenshot of an Austin Select Plumbing?
I do recognize that screenshot.
Okay. Ms. LeBron, other than the $120 to Austin Select Plumbing, did you incur any additional out-of-pocket expenses for repairs?
No, Your Honor.
Okay.
I know that I can't repair anything without his permission, so I didn't repair anything on my own.
That's absolutely accurate. Yep, there's it's very specific rules around that. It can be done sometimes, but you gotta do a whole lot to kind of establish that that right exists. So the 120 is that. Okay. Ms. LeBron, you said that you were seeking a counterclaim, and how did you calculate to the $16,000? Because so far I see 120 out of pocket. I see that there were repairs. These things went unhounded. How are you calculating your damages?
So $55 at 12 months, that's $660 for the no smart home equipment as advertised.
And where does the $55 come from?
He claimed to have increased the rent by $55 a month due to the smart home features. This was a great home, it's fully loaded smart home.
When did he make that $55 claim and how did he do so?
He sent me, we had a conversation about it after he changed the lease agreement. After we came to terms on what the rent would be, he made unilateral changes to the rent and the deposit. We had a conversation about it. At this point, I'm stuck. I need a place to move into where we've already signed everything. I've got limited amount of time to move. And so we had a conversation about it and he was justifying his changes by saying that it was for the smart home. So $55 because the home was initially going to be $2,095. And so it went to $3,050 per month. And so he said that $55 increase was for the smart home and the features of the home.
Mr. Albert, is that correct?
None of it's correct. None of this is correct.
All right, Miss LeBron, do you have any of that in writing or historic documents?
I do have it in text messages, Your Honor. I'm not sure if I submitted it today. I was trying to go back through all of our text messages in advance and my daughter just got out of the hospital. I don't know that I submitted that today. I did submit where he marketed the home with with all of the smart features and use that to justify the rent.
I'd say that if you marketed it that way, then he shouldn't have increased the rent after you signed the lease. It would have been part of it. So you're gonna need to find for me something to establish that $55 out of the $30.50 was for the smart home stuff.
Yes, Your Honor.
All right, what else was in your calculations of the 16,000?
So I put $998.33 divided by 11, and that's 10,000, or I'm not divided by 11, Your Honor, multiplied by 11, which is a total of $10,981.63, which represents 1/3 of the rent paid over 11 months for a house that we did not have the use or benefit from, including the bedrooms, bathrooms, garage, outlets, refrigerator, shower. I couldn't blow dry my hair, Your Honor, for a year. I couldn't use the bathroom to blow dry my hair or use my electric toothbrush.
Did you have a bathroom that worked in the house?
None of the outlets, Your Honor. there were a couple of outlets in the kitchen that worked.
Ms. LeBron, do you have a written communication to the landlord where you tell him, I can't use any of the outlets in the house?
Yes, Your Honor. So when we go back to the emails, I think I even referenced, I can't blow dry my hair. I will have to find it, Your Honor.
Where did
February,
you charge your cell phone up?
I'm telling you, Your Honor, there were 1 or 2 outlets throughout the house that worked. There was like 1 in the kitchen, and I would move the, and the city found this as well, Your Honor. But I would move the things that I needed to use to that 1 outlet. I don't know what Mr. Alpert did to this home. And you can see on how he marketed it that he had wired it for an RV, and there were just wires hanging everywhere. So I don't know what he did.
So the giant bulk of your claim is for the lack of electricity outlets working?
Well, no, Your Honor, it's for not having access to the garage, the bedrooms, the bathrooms. There was,
Ms. LeBron, were you able to access the garage? Could you open the door and go in the garage?
no, because they were completely off the hinges. When the first time, Your Honor, this house was like, if you see a car and it looks good,
Ms. LeBron, is the only way to get in the garage from the front door, or is there a door from the house into the garage?
there's a door from the house into the
Did
garage.
that door work?
Yes, and there was
So
blocked
then
by
you
a dryer.
So what you couldn't do was use the garage door in the manner that it was meant to, but the garage was accessible from the house.
I couldn't put my car in the garage because the doors were off the hinges, and there was a dryer blocking the door from the house. The dryer that sat there for an entire year.
And other than the email you showed me where you asked him to move it, are there any other moments about that?
Yes, Your Honor, there were texts and emails, and Mr. Alpert submitted his in evidence too. That's why there's 100 and something different things. Those are all emails of me emailing about and texting about the repairs on February 6th. And it's an email titled Mark February email work orders. And Your Honor, I haven't really been able to do an opening statement to really kind of.
Ms. LeBron, well, I don't need an opening statement. You told me that you're suing him in counterclaim for $16,000 and change, correct?
Yes, Your Honor.
Got it. You let me know right up. That is an opening statement. What do I want? I want $16,000. What I want it for, because I didn't get the benefit of the bargain. Here's all the things that he told me I was going to receive and I didn't get them. Now I'm asking you to show me an evidence. Can you support that claim of $16,000? So far, you're showing me that there were issues outstanding for the electrical situation, that there was trash still in the house that he was supposed to remove, and as a result, you couldn't access all of the exterior areas, that there was window gapping, that the garage door did not work as it should, that the upstairs shower kept flooding into the kitchen. Those things have been established through historical records. Now I'm getting into, are they worth $16,000? Right?
Yes, Your Honor.
So that's where we're into the prove up of your damages. So if you're going to tell me that so far you've proven $120, because that's an actual out-of-pocket expense, I see that.
Right.
Now we're getting into, how did you come up with that gigantic $16,000 number if you've only been out of pocket $120? And you said to me, $55 by 12 months would be for the lack of a smart home. That was how it was advertised. That was what I was supposed to receive, and I didn't get it. And that he told me $55 of the rent was supposed to cover that. That's how you figured that out. I love that. Then I said, what's the rest of it? And you said, well, I want $998.33. That's a very particular number. And you want that for 11 months because that's what you calculated to be the third of the house value. And you said that you couldn't use a whole third of the house because no outlets work. And you were going through that. And I'm questioning you. What you're telling me is a big assertion. And what I'm doing is putting a legal lens on it. So though the garage door didn't open and close, the garage was accessible through the door from inside the house. Yes, you couldn't use it for a garage to put a car in, but you could store boxes. You could put your trash in there.
Well, it was blocked.
Some use. It has use. It's not the full intended use, right? So what I'm getting into is, are you establishing all of that? So the garage door didn't open and shut from the outside, but you could get in from the inside. I've had cases where the landlord literally put a lock on it and they could never access the garage. That's very different. Right.
There was a dryer blocking the interior door into the garage. The dryer was blocking that, sitting on the ledge just outside the door. So just for whatever that's worth, FYI, you couldn't even open the door.
Okay, so the
And I-
garage, is it a 1-car or 2-car garage?
It was 2 or 3 car garage.
Well, you gotta know that. Is it 2 or 3? There's a big difference.
I wasn't able to access it, Your Honor. Mr. Alpert would probably know better than me. There were
From
2
the front
garage
of the
doors.
house, Miss LeBron, is it a 2-car entrance or 3?
There's 2 garage doors.
And it's a 2-car garage. All right, other than the garage, you said you weren't able to access other parts of the house. I know that you couldn't use the electrical outlets, but the rooms themselves, you could open the door and go into them?
Yes, Your Honor.
Did the lights in the ceiling work?
Yes, Your Honor.
So it's just the outlets.
So it was the outlets, and then in the bedrooms for my children, which I sent to Mark multiple times, like they're freezing. They couldn't sleep in their bedrooms because of the issues with the windows, which Mark knew about and had promised to fix at the time of move-in.
Have you come up with an amount that you think is for that?
That was the total, Your Honor, representing basically a third of not being able to use the home. With all of the collective issues, the total was $998.33 a month of the $3,050 rent.
All right, now how about the windows? What was wrong particularly with the windows? Did the windows open and shut?
No,
Could you open windows?
no, there were 2 windows that were stuck open, and those were in the kitchen. There was a window, there were windows around the front door and a window above the door. The first month that I lived in the home, Mark did replace the window over the front door because it was pouring water. And so he waited until I moved in and could coordinate with the contractors. And I was disrupted the first month while they replaced that, and they no-showed multiple times. And he was supposed to have the remaining windows, like from the bedrooms and from the front entry, replaced because water was coming in both around the front door. There was mold and there were issues with the breakdown of the front door. I could not close or lock the front door on many occasions, Your Honor. If you open the front door, the entire front door fixture, like the wood around it, came with the door, Your Honor. So
Did
I
you-
could not.
Ms. LeBron, did you make a written request for repair for any of those issues?
Yes, Your Honor.
Did you send a copy of that letter to us?
I'm looking through the evidence. Mr. Alpert, when he had the kitchen sink guy come and look at the shower, he looked at the doorknob, he said, "This is shot, this needs to be replaced," and then he never came back. If you look at the February 6th, mark February email work orders, and it's from February 6th.
Do you have any others besides this February set? Any in March, April, May, June, July, August, any time up until you moved out other than February?
Yes, I do, Your Honor, but we still have not gotten to submit the February 6th email, so that's what I'm asking, because we talked about a February 2nd email.
That's this
Is
one
that-
here. About the freezer. I've never installed a freezer. I don't own one. You acknowledged it in writing issues with electric and the GFCI. The shower was a known problem. What on earth are you talking about? I've reported the outlets have a problem. When will you repair the garage doors? I don't believe bulk pickup is gonna come along. You gave us a smart house marketing, but I haven't gotten any of that. The windows, you sent me a message about needing repair, like I dealt with the door and the window repair after moving that was to be done prior, and so they're leaking and air is getting inside. Should I be charging you trip fees for this? Mr. Albert, you recognize this email, February 6th?
Isn't that the same one you just showed me earlier?
No, that was February 2nd.
Oh, second. Oh, I do recall that email from her. I'd like to read the whole thing though, because I'm,
Yeah, this is yours. This is the other one. So I've read your response to the deposit lien about how you believe you've already paid it. I see the lease we all signed and dated October 12th, details and penny, the deposit's 2050, the pet agreement's 300, and there's a 125 one-time non-refundable. Okay. You paid 2050 via Venmo. As for reported issues, Dwayne's expected to look at the shower, so we've got an issue in the shower. I've also shared the sudden generalized issue with electrical, a GFCI breaker that is not a covered landlord expense. Those implements are working properly for safety. You installed a freezer in the garage on a GFCI plug, and that's what she said. I don't know what you're talking about. We've never had a freezer. I'll ask Dwayne to send me a picture of the brush. I'm not maintaining a fence nor replacing any more windows or doors. I'm not providing assurances about smart switches. I'd be happy to help walk you through repairing your hub to them. Oh, you through pairing your hub to them if you'd like, but they also work manually. If we do not agree, please refer to 15A and B. Okay. This is from the 6th. As you know, you had a pet deposit and pet fee. I've made reminders to request this be paid. So he's saying you didn't pay the pet fee.
And I'm saying that it was included in the deposit that I paid, which was our agreement.
So you didn't pay the $300 after that. You just paid $20.50 flat out.
No, I did. I did after he asked me to, but this was more of the changes that he made. And so,
I'm just making sure. So you did finally pay the $300 pet deposit, but you'd already moved in by the time you paid it.
yeah, I paid $425 total. We didn't want to argue with him. He just kept, it was like a bait and switch for everything. And so when he sent that to us, Chris just said, send me the Venmo. I'll take care of this. Like at this point, we were like, we don't know what's wrong here.
All right, Mr. Albert, that's the end of that chain of emails.
Do I?
Just you said you wanted to see them all. That's it in that particular evidence.
Oh, okay.
All right, so that would be Defendant's Exhibit 3. The emails February 6th. It's actually an email chain between the parties about multiple issues and about the pet deposit.
Your Honor, and on the plumbing receipt email, if we can pull that one up, it's dated February 14th. I talk about the issues with getting him to repair the active flood and how I repaired it at his request, but below that in that email, I also outlined repairs. The front door doesn't close. We knew the front door didn't lock because it didn't close, but I talked about all of this. I said, the second bath is still pouring in water into downstairs.
Ms. LeBron, real quick, because I'm reading the email. Did you deduct 120 from the rent the following month?
I did, Your Honor, but he screamed at us about it, so then I paid it again to prevent him from, I mean, he was just insanely hostile. And so I tried to deduct it like we talked about.
LeBron, let me read the email. Let me read the email. I see that there. I'm curious because you told me that you had paid that. So I want to make sure that is an out-of-pocket expense. And it is. Okay. Here's the receipt for the plumber. Toilet paper related to that, about 5 years worth of hair. Okay. To recap, I contacted you and spent quite a bit of time sending messages and videos that looked at trade outs and talking with you. Going forward, I'll send you non-functional items needing repaired. You can have a professional come to diagnose and repair. This is most appropriate. Following notification, you sent Dwayne out to look. He couldn't fix it. Said he would need to go buy parts. Wasn't confident. He said we needed a plumber. You seemed to question why you would ask that he repair, reiterating that we needed a plumber. Hearsay. At the same time as he was here, he's going to install a regular faucet on the bathtub.
By regular faucet, I mean like an actual like 1980s, like old school, like bathroom sink faucet or kitchens, like just, it was bizarre, Your Honor.
Ms. LeBron, this email is dated February 14th. And
Yes,
your first email was dated February 2nd. Had you been experiencing the water problem throughout that time?
Yes, Your Honor. So it started in October and we started with the text messages with which Mr. Alpert submitted for evidence. We started with text because at first I was being very friendly with Mr. Alpert. I had no reason to believe that I was being scammed or he wasn't fixing things. And so I'm sending him, hey, here's a list of items. We're communicating just fine. I'm sending it via text.
Hold on, this is where it slowed down. So I've told you all before, I video court in as fast as I can until I catch up. And then I can never tell because sometimes people from Texas talk so slow. But Thank you all so much for liking. I'm going to play this again as soon as we're done here. Everybody in here has already liked, so this video has 100% compliance, which is excellent. But I really, yeah, like the slowdown of the voice is really funny. I would love to hear what you guys think in the chat. Who you think is going to win? We'll go with 1 for the landlord and 2 for the tenant. 1 for the landlord, 2 for the tenant. Oh, me neither, Prissy, but I don't know. I'm hyper aware of it because there's not anything that changes visibly that much. And sometimes I'll be doing stuff and listening and not necessarily paying attention right away, and I don't want to mess up the videos or whatever. So anyways, 1 for the, what did I say? 1 for the landlord, 2 for the tenant. Kickstart didn't happen for which one? And okay, here we go. We are back onto 1 speed.
And he's calling me, yelling. He starts texting and calling all hours of the night. So we took it to email in January and February.
I don't disagree that that would be reasonable, but it's not required by law. They can just hire someone off of Craigslist as long as,
It was a request, Your Honor, just for our safety.
Ms. LeBron, your concerns are common, and there are people who would be observing today via YouTube because they watch these dockets to understand their own cases coming forward. So I want to highlight for you and for others that this is not unreasonable to request, but not necessarily required by law.
Yes, I understand, Your Honor.
Right? But that's a part to distinction in this, because a lot of what I'm hearing from both you and the plaintiff is emotionally vested. And I'm trying to get you right back down to what legally can you support and legally are you entitled to on either side.
Yeah.
Right?
I
The
understand.
frustration, I understand, but it doesn't further the case in any way, because there's no.
I didn't make it part of. Yeah, I didn't make it part of the claim. I just, it was an ask for the safety of me and my young daughters. Is there any kind of vetting, for the people that are coming out here? I never denied them access. I always opened the door, even with no notice. There were no shows. Somebody came out to the home on 3 occasions total. The rest were no shows, but I never not opened the door.
That hasn't been alleged, Ms. LeBron. Mr. Alpert, do you recognize this email here? This one from Ms. Leanne, from Ms. LeBron on February 14th of 2022 to you at that address with the receipt for the plumber and the information again?
I do recognize that email.
Okay. We mark this defendant's exhibit 4.
And you can see in his text message, Your Honor, he said, we can cancel Dwayne, go with the 175 you found. It actually ended up being only 120. So there were savings. It was, the guy was decent. He took care of it pretty quickly. But Mark asked me to make this repair. I made the repair, and then he did crazy making in the morning, which was just bizarre, and threatened to charge me a trip charge and refused to reimburse the expense. But in that email, you can see that I'm talking again about the repairs, the multiple repairs. I talk about the outlets, the door.
Ms. LeBron, I saw it. Okay. This is February.
Mhm.
What happened in March? Did all of these problems persist?
Yes, Your Honor.
How about in May and April and all of the months until you moved out? Did these problems persist?
Yes, Your Honor. Nothing was ever repaired.
Did you ever make another written request for repair?
Yes, Your Honor. It went on and on. There's an email chain, and it is titled Continued Follow-Up on Work Order Requests. This one's from May 17th. And for the interest of the court's time, I didn't submit the thousands of pages of all of the communications, but I have May 17th.
Did you submit the May 17th to us with your paperwork?
Yes, Your Honor. It's Continued Follow-Up on Work Orders is the name of that one.
Let me see if I can find that. I see that.
So I emailed on May 9th and on May 17th.
Let me share my screen so you can identify this document. All right, Ms. LeBron, you recognize this? This is titled May 17th, 2022. I see it from a Leanne to a Mark Alpert.
Yes, Your Honor, that's it.
Okay, and this is an email chain between you and the plaintiff?
Yes, Your Honor.
All right, I can see that this is May 17th, but it looks like the original message was May 9th, or that's included here.
Yes, Your Honor.
All right, I can see it on May 9th. Hi, Mark. Hope you had a nice weekend and a nice Mother's Day. How would you like to move forward with good resident relations at the forefront as it relates to the late fees? I'm asking you to waive those and mail the payment at 4:30 and set via an alternate method as it relates to the 120. This was agreed upon. I predicted for and catching up on that now. Garage doors. Upstairs bath. Electrical. Windows. Front door again. And this is a follow-up. So from her, she wrote quite the hostile email. I don't see it necessary to rehash what's already been discussed. Just a couple reminders. Dwayne attempted twice, was unable to resolve the downstairs plumbing. You asked me to connect another plumber. I did. I got it for 120. Shower still not fixed. Dwayne's not doing that. Electrical doesn't work. Been gracious and grateful for months. Dwayne's still not getting the front door fixed. Plumbing repairs I deducted. Brace on the purported late fees. I mailed you the payment. What is this screenshot, Miss LeBron?
I'm not sure. He was trying to prove up something, claiming that Dwayne was going to come back out and make some repair to the bathroom that was already repaired, the one that I paid for. And so he sent a text message, and it was, I don't know what he was trying to say, but there was one time where the repair guy who wanted to come out for the issue that was already repaired sent a text message. And I said, I'm sick. Kai just got out of the hospital. We'll have to see what day works. I have a daughter with a complicated medical situation. And so I'm like, hey, I'm sick. Kai just got out of the hospital. And so I don't know what he was trying to say there, but he included it in some email trying to allege something. He's claiming that things were fixed. I'm telling you, like, you can't fix an upstairs shower head with a 1980s like stock sink faucet. It's not going to work.
All right,
So
Mr. Alpert, do you recognize this chain of emails and communications between the parties starting around May 2nd? Looks like it continued on May 7th, May 9th, May 16th.
I mean, you're going pretty quickly, but yeah, I do recall.
Okay.
I do recall.
All right, this would be Plaintiff's Exhibit 5, the May email communications. I'm sorry, Defendant's Exhibit 5.
And Your Honor, I just want to note that throughout, both Chris and I had asked Mr. Alpert to please only contact me. He continued contacting Chris, but he claimed that he was afraid to contact me after I said one time not to contact me. That's not true, Your Honor, because he continued to contact, Chris no matter what.
Okay. After the May emails where you requested repairs, anything else until October?
Yes, Your Honor, there were multiple. Again, I didn't submit every single one of them. Just in the interest of time, I kind of highlighted the ones that showed the issues over time. He never, repaired anything. He claims I didn't leave any notice. I've got 2 different emails where I gave a notice to vacate that was timely. And we submitted those, and I have those in my evidence as well.
I'm curious about repairs. I've seen February, I've seen May. Any other communications about repairs needed between May and you moving out?
No, I think Mark submitted his, but just like I said, for the interest of the court's time, it was basically establishing that these were the repairs from the beginning. They never got repaired. None of them. And then the city of Austin cited the majority of those as issues as well.
Did you contact code compliance or did they come out of their own volition?
No, Your Honor, I believe it was the HOA because the exterior of the home, the way that the exterior of the home looked.
Did you take any photos of move in or move out?
So, Your Honor, I took photos and I have it in evidence. Let me find what it's called and I apologize. House photos upon move out.
Fantastic. I see that, house photos while moving out. All right, are you wanting me to look to these or are these going to be illustrative of any of the items highlighted here?
So it is an illustration of what the home looked like when I moved out. He claims I left it in bad condition. The home looked fine. It was the functioning and the access of the home, but you can see hanging wires. You can see the dryer in front of the door. You can see a couple of the outlets off in there. You can see the garage door off the hinges.
All right, Ms. LeBron, do you recognize this photo?
Yes, Your Honor.
I have 23 photos. Did you take these pictures?
Yes, Your Honor.
When did you take these pictures?
So I took those pictures, I believe, on October 29th. I was moving out of the home and Mr. Alpert locked me out of the home on October 30th. And I've submitted photos and videos of me being locked out in the middle of moving out.
Oh, okay, that's more than I asked. You took this photo and you took it October 29th.
Yes, Your Honor.
Fantastic. Just trying to prove up who took it, that it's valid to come in here. So you have knowledge because you took these photos. What is this a photo of, Ms. LeBron?
It's a photo of the living room of the
Living
home
room. Great.
after I
And
moved.
how about
as a-
this?
Living room,
Living room. This one
living room,
looks nice. This one,
kitchen.
this one.
Oh, that was a back room downstairs,
Okay.
the restroom downstairs. That was the laundry room. That was the dryer in front of the back door. You couldn't really open the door.
I mean, okay.
That was the stairs. So you can see like the walls. I mean, I didn't leave the place in any bad condition.
What's this a photo of?
I don't know, Your Honor. It's
Okay.
somewhere in the house.
Living room again?
A bedroom.
Oh, wow, that's nice.
That was another bedroom. It had, when we moved in, 20-plus-year-old carpet that was stained. So that was just the carpet that was there when we moved in.
Okay. How about this one?
Staircase just to see like the walls and the condition that we left it in. That was the closet with some of the hanging wires. I don't know what that next one is, just random photos of the home and some of the outlets off.
What's the phone jack?
That was,
Door.
yeah, off the hinge there.
You were able to get in the garage to take that picture?
I took it from the door. This, Your Honor, is where he locked me out and I left the keys there for the neighbor to pick up, which they did. That's the garage clicker and the key after he locked me out in the middle of me moving out with some of my things still inside.
Were you able to retrieve your items, Ms. LeBron?
No, Your Honor.
Did you contact the plaintiff about getting access to the property again?
I spoke to the neighbor. That's who was marketing it and who had put the lock on.
Did they grant you access to get your items?
No, Your Honor.
Did they refuse you access?
Yes, Your Honor.
Did you call the landlord and say, let me in? I still have a day left on my lease?
No, Your Honor.
All right. Any other information? Oh, I'm sorry, first, Mr. Albert, any objection to these photos being an accurate set of photos taken by the defendant on or about her last day there?
Don't have any objections to that, but I mean, there's no evidence on any of this brush or any other problem she's saying I left behind.
All right, she's got a historic record of that I take to be very reliable, because she wrote 3 emails over a period of 4 months about it, and most people don't make that up and then persist with it. Especially since your
I'm
emails don't
stating it
deny it.
wasn't there. It wasn't
I-
there. And I'm saying a lot of this
Mr. Alpert, as the finder of fact, I find her testimony to be very credible
Okay.
about there being evidence of that, because she has 3 historic records of it.
Okay, do I get to provide a response to some of this? It might change your mind.
Absolutely, you're both going to get to come back and forth. I'm just making sure any objection to these photos being photos that she took on or about October 29th and the 30th.
Oh, those pictures look reasonable.
Okay, so admitted, that's defendant's exhibit. All right, Ms. LeBron, do you have any other information that you want to present to support your counterclaim?
Yes, Your Honor. So what I asked for was reimbursement of the rent for lack of use of the home, for it not being what was marketed. I asked for $120 for the actual cost they paid for the repair of his toilet seal, $20.50 return of my deposit. But I'm asking for 3 times the deposit, Your Honor, because he never provided.
Why would you get back your deposit if you used it to pay the last month of rent?
Well, that's what I'm saying. He's arguing both here, Your Honor. He's saying he used it to pay the last month of rent and also that I owe him for the last month of rent. So he's saying both and not deducting anywhere for the deposit. I'm saying, Your Honor, that I don't owe the last month of rent because the city of Austin condemned it.
No, they
And
didn't.
well, they said.
They
submitted
did
a
not.
notice
Okay,
could not
go
be
ahead, tell me your position, and I'm just going to say that's not how it happened. But go ahead.
On the first page of the city of Austin notice, it said it could not be rented. They said they needed to contact Austin Code. So I'm saying that from that point, rent was not due on that last month based on the city of Austin notice. And I'm saying, well, what I'm asking, Your Honor, requesting is the $2,050 return of the security deposit times 3. There was no accounting for the security deposit. There was no itemized statement. There was no information. There's the $300 pet deposit that was never returned, Your Honor, times 3. I'm requesting times 3 of the $300 pet deposit.
You don't get bad faith on pet deposits, but I like it. Keep going. I mean, I appreciate it. It's a property code issue though, and that's not, well, go ahead.
I'm asking for the return of the $1,000 paid on October 1st for the uninhabitable home. I'm asking for $1,500 for harassment, retaliation, and emotional distress, Your Honor. It was an extremely stressful year with multiple threats. He was threatening to cancel the lease agreement anytime I made.
Keep going. That's not actionable under Texas law. I get it. It's frustrating. I can see that y'all had a horrible leasing experience, and he probably feels the same way. But that's not actionable under Texas law. This is a contract case. What else do you want?
So that's what I asked for in my pleading.
Okay,
in
you want back the $20.50, you want the $120, you want your $300 trebled, you want 12 months at $55 for lack of smart home, and you want the $998.33 for the 11 months because you couldn't use the rooms that didn't have outlets working.
The return of the $1,000 for October for the uninhabitable home, and then 3 times the deposit of $2,050.
All right.
So, Your Honor, I wanted to just sort of say that, you know, we had the issue of him misrepresenting the property, the condition, the features of the property. He changed the rental rate and the deposit after we applied and signed documents. Each time he would write us, you know, harassing email this, we paid whatever he asked us to pay. He said, oh, I've charged an extra $425, which was already included in the initial security deposit. We paid that. When we were supposed to deduct the $120 that we paid for his repair, he starts yelling at us. That's where he claims on the October statement, Your Honor, that it was $120 late from May. I went ahead and I paid the $120 just to make good, just to keep peace, even though that was what he told me to pay for his, you know, repair, that he would pay for that. You know, after we moved in, Mr. Alpert acknowledged all of these issues. He acknowledged the bathroom flooding into the downstairs. He acknowledged the electrical issues. In each conversation that we had, he acknowledged the windows that were pouring in water and air and the elements from outside. He acknowledged that I could not close the front door, Your Honor. I couldn't lock the door. There were so many issues with this home. I would, on times, depending on swelling, right, whether it's hot or cold, There were times that the door would close. I would come home, open the door, and the entire door frame came with it. This was the experience. No
Did you take
matter
any
what.
photos of that?
Yes, Your Honor, they should be in that, but they're also, it was part of the Austin Code compliance.
No, I want to see your historical photos of the door falling in.
Let me, if they're not in there, it's only because they didn't transmit in my PDF, because they should be in there. Hold on, house photos. You could see like the deterioration of the sill and the door, the entire jam would come with it. But I'm trying to see if it's on my PDF. I know it was part of the city of Austin. I'm searching my PDF. It looks like it did not come with the PDF. There were 3 things that did not transmit with this PDF that I sent over, Your Honor. So we both couldn't lock it, couldn't close it some of the times. And all along, I'm trying to work with him. Hey, how do we have good resident relations? He took it as an affront, like he needed to beat me or fight with me because I'm reporting repairs. And you threatened to cancel the lease agreement. In that case, we're out. This is during COVID crazy housing market, Your Honor. There's nowhere to go. I'm trying to work it out with him. I'm trying to get the repairs resolved. He acknowledged every single one of them. We've got the exposed wires, the smart home features. We've got all of these issues. There were no smoke detectors in the entire home with outlets that were sparking. The outlets fried one of our computer chargers and Chromebooks for my daughter for school. There were no carbon monoxide detectors as required by law and code. The fridge and freezer issues. There was trash and debris all over the property. He left the dryer.
LeBron, I get it. You have established your side. What more do you need to prove to show me $16,000 of damages? Like, you've met your burden. I'm ready to hear from the plaintiff again. Do you have any other evidence? Because what you're doing is you're piling on, and I got it. You had a bad experience. There's a lot of things that weren't done. Is there anything else besides those items that you've given me evidence of that is part of your $16,000 claim?
Give me just one moment, Your Honor. I'm so sorry. I'm looking over this. Another thing that I'd like to mention, Your Honor, and I know that it's not part, you said under Texas law for like the harassment. The neighbors.
Miss LeBron, I'm going to emphasize this again. You have met your burden off for many of these things here. So what more evidence do you have?
Yeah, I just wanted to say that we were subjected to racial treatment with racial slurs being said to us by his agent who was marketing the home. We had plentiful issues.
Miss LeBron, you've made a really wild statement, and unless you are ready to testify and tell me exactly what those slurs were and that you heard them yourself, you're just painting stripes. Were you present to hear those racial slurs?
Yes, Your Honor.
What day did those occur?
This was just before October. It was not long before we started to move out, so it had to have been in September. His agent and neighbor came over to our yard, and we didn't have bad relations with them. I didn't know them. I assumed that Mark was speaking to them about us, but we didn't have bad relations with them at all. But she came over to our yard and she was talking about how they pay their property taxes to keep Black people out, knowing obviously that my children are biracial and having seen my children for almost the past year.
What's the name of that agent?
Chris is the guy's name. I don't know the woman's name. The wife.
Who said it?
It was Chris's wife. Those two are his agent who marketed the property, who locked the doors, who I don't know what all their relationship is, but they're friends and they were responsible for the house in various ways, but it was Chris's wife.
Okay. Anything else?
So the things that were left behind, there's actually a photo in the housing exhibit. I had a box and there were some boxes left in the closet filled with shoes. And those were the things that I was never able to get back from the home. When he just locked the door, he put the lock on. I pulled up to the house. I took a video. Your Honor, I also have 2 videos to submit where I recorded me coming to the home to finish moving out and finish cleaning. And in the video, I say it's, October 30th or October 31st, and I'm locked out of the house. I can't get in. I can't finish moving out. So I have those videos to submit. And I also have some text messages from Mark Alpert where he's saying that the home is good to go, it's good to rent, but he wants to upgrade the floors. This is after I moved out, showing that there were no damages to the home and that he was not prevented from leasing the home. He chose to not lease the home.
No, Ms. LeBron, you've already proven why he couldn't relet it. It was condemned, remember? Part of your testimony is that you should get back all the October rent because the house wasn't livable.
That is part of it, Your Honor.
Oh,
but
then let's watch the video. Is this
Okay.
video going to assert for me that you were not permitted access to the property?
it shows that the door is locked. There was nobody there at that time, and it shows me leaving the key in the garage clicker there. There are 2 videos.
A plugin is needed to show an iPhone screen. Wouldn't you know it?
Sorry, Your Honor.
No, that's okay. That's just how it works. Let me make sure I am sharing the audio too. Are y'all seeing this video now? Oh, that never fails. Jamie, do you have the permission on yours already? Because I mean, it's playing on mine. It's a matter of sharing it to the screen here.
Let me see if it'll let me share. Just one moment.
Okay. I'm getting caught in permission heck. Is there sound?
Yes, Your Honor, there should be.
It is playing sound. Let me see. It should be doing it. One moment.
Thank you, Jamie.
It's October 31st. My lease is not up. I can't finish moving out. So please.
Ms. LeBron, you created this video?
Sorry, I was having an issue. I'm sorry, Your Honor. Yes, I did.
And what am I looking at in this video? Is this?
It's the lockbox on the door, and it's that large thing is the garage clicker. And I left the garage clicker and the keys right there by the door, and the neighbor retrieved them.
All right, Mr. Alpert, I'm sorry. Any objection to this being an accurate video she took on the October 31st of the front door of the lockbox?
She's not, I don't trust any of this. I don't trust anything she's saying. I don't trust this October 31st because I didn't put anything on there till November. So I don't trust any of this.
All right, Mr. Alpert, do you have your agent here who can testify as to when they put that box on?
No, I mean, I have to show proof when I put that box on there.
Here's how it works, y'all. Both sides can present all the evidence you want, and I take them as truthful unless there's evidence within it to tell me that I should weaken it, right? Which is why I'm poking holes in everything y'all shown me.
Right.
He's given me something which on its face has an indicia of reliability. I have no reason to disbelieve that. If you want me to disbelieve it, you can bring the evidence to say it should be lessened. Otherwise, I take it as a video. Maybe it's proof of something.
Okay, well then why didn't she just go through the garage with the clicker?
Because the garage door didn't open, and she's made 4 requests for repair at least. Right? How about that answer? Because she has proven to thee a historical record of that. What I'm confused about is how y'all got here at all. It definitely strikes me, Mr. Alpert, that the defendant here is sufficiently supporting a counterclaim. And both parties broke the law in how they handled the security deposit.
Okay, but
I'm
I believe when you hear my response to her things, you might feel differently.
maybe so. I'm just, any objection to that video? You said you don't trust it, but that's your only objection to it.
I've never seen it. She's never presented that to me.
Front door.
And she's never, and if I did lock her out, then then I'm required to within so many hours open up. Can she show a call log to me during that time?
No, she told me she didn't call you, sir. She decided it wasn't worth it. She didn't want to pursue it.
Okay. Well, if someone got locked out, which I would never do, but if you want to go down that path, what did she do to try to gain access? I mean, all I see is a video.
Mr. Alpert, I'm not asking you for you to argue with me about her evidence. I asked if you have any objection. You have voiced an objection. I'm overruling it. I'm going to admit it.
All right.
It's a video of a front door with a lockbox on it. The video isn't dated. She says something in it, but I'm with you. I don't have any metadata. Ms. LeBron, if you have data to prove when that video was created, that would strengthen your evidence. Otherwise, Mr. Alpert has pointed out an obvious thing. Anyone can make a video and say it's that date.
I made 2 videos, Your Honor, and I could show in my phone, I could screenshot the date that the video was taken in my phone, but that's why I said the date on the phone, or on the video, but I took another one as I was driving up too.
Okay.
So there were 2 different videos, and this was to say I'm locked out. By this time, he'd already sued me for money that he had in his possession that was, owed back to me on this uninhabitable residence that he had. At this point, he's already sued me. He's locked me out. It's just.
What had he sued you for? Had you been given notice of a lawsuit?
He had already sued me in small claims in October 14th or something before I ever moved out.
Yeah, that's correct, Mr. Alpert. This was filed October 5th. This is before her lease ends.
But it wasn't an eviction. It was just, I knew that she wasn't going to pay rent. So I wanted to have her served before she moved out, and she evaded service.
All right. I got it. You're going to get a chance to respond. Okay, Ms. LeBron, any other evidence to prove your damages of $16,000?
I don't think so, Your Honor, beyond my testimony.
All right, Mr. Alpert, do you have any questions for Ms. LeBron?
Yes. You mentioned that there was brush. Did you take any pictures? I mean, you took pictures of the door, with the lock. Did you take any pictures of any brush that needed to be picked up?
Yes, Mark, and we exchanged emails and I sent them to you and you sent your son out.
Did you admit it into oh, so my son came out and what did he do?
He didn't take care of the brush or the trees or
What
any
did
of
he
the
do?
wood. I don't know what your son did, but you sent him out for that purpose.
So you say he just sat there and he didn't move any brush to the curb?
No, there was a wood pile, there was brush, there were trees.
So what did he do? Did you know anything that he did?
No,
Okay, you mentioned that the windows didn't close. Do you have any pictures of that showing that they don't close?
the 2 windows in the kitchen did not close and the windows in the bedrooms and the front did not open. But the city of Austin notated those issues on their code compliance.
Yeah, where did they note it on the code compliance that they don't close? Can you show me? Or can anybody show me?
You would have to read the document, Mr. Alpert, where they talk about the windows needing repair. Some were broken, some.
It's your evidence, and I don't recall code compliance saying anything about windows not closing.
Okay, so you would
Oh.
I just feel like he's being abusive, Your Honor, and this is, I'm gonna.
Ms. LeBron, just refer to the report. Is there a specific spot that speaks to that? This is called cross-exam. He's allowed to be a bit pointed. You get to do the same thing when you ask him questions in a moment, right? If I think y'all are going over the line, I'm going to interfere and I'm going to tell you both to calm down. Because I'll tell you right now, I'm a little bit of both parties take nothing. I think both parties have acted in bad faith. You both broke the law related to your deposit. Mr. Alpert, you didn't itemize, you didn't refund it. She's entitled to treble. In fact, statute says if you don't send that notice in 30 days, your right to take any deductions is over. It's finite, done. You missed your opportunity. And so, Ms. LeBron, I come back to your counterclaim. You want me to award you a whole lot of money despite the fact that you took absolutely no steps to improve or take your legal rights. And no, I'm a judge. That's what I do. There are multiple avenues that you had available to you in this court right here to fix this problem, and you sought none of them. But now you want a bunch of money.
Well, Your Honor, I filed a counterclaim.
I know that, but for him suing you, you wouldn't have pursued him. You lived there for 12 months, and what you're describing in all but all words, calling it a hellhole. No power. My kids were unsafe. We couldn't lock the door. It was freezing, and yet you didn't move. I saw the email where he offered to let you break it. And what you said to me was, oh, it was too hard, Judge. It's not too hard if your kids in prison and you can't lock the front door. You absolutely have rights of repair. I don't understand why either party in this situation behaved in such a lackadaisical manner when you're both, when I strike me as qualified professionals. Chris Harrison keeps on it as a CEO. So people here have the ability to read a letter. I can see that y'all wrote a ton of stuff to one another, and yet neither of you took effective, appropriate legal action to improve your situation.
Well, Your Honor, I made the requests for the repairs, and as it relates,
you did nothing when they went dead. The statute in Texas authorizes you an increasing set of repair remedies, and you did not seek those, Ms. LeBron, including the ability to end the lease for self-help.
Can I explain something to Your Honor?
What is there to explain?
During COVID and the crazy housing market, if you have
2022 is not the height of COVID, Ms. LeBron.
2021, Your Honor, and 2022. The market was still insane. There's minimal houses. And if you have a bad relationship with your landlord or a bad rental reference, it's not easy for you to move. I'm thinking, can we work this out? Can he make the repairs?
But legally, the law, y'all, let's be clear about something again. The law is what the bare minimum is. That's just barely passing. What y'all often come to court and want is what you were advertised, which is like an A grade. The law says as long as you got C, you're sufficient. What I'm listening for here in all of your allegations with each other was the law met, right? On his original claim, Mr. Alpert, you told me that she didn't pay the last month's rent because she let you keep the deposit. Everyone has agreed on that fact. It is a fact that to do that is a violation of both the law and the lease. So, Ms. LeBron, you broke the lease and the law when you did that. What you're telling me is that you felt justified in doing it. That may be so. That doesn't make it legal. And Mr. Alpert, you felt justified in not bothering to itemize or refund any portion of the deposit because she told you not to bother her. I don't care what she says. You're a real estate broker. You absolutely are supposed to know better, and you are aware of that per your license and the lease that you used. It's a TR lease. So again, I've got a sophisticated plaintiff here, and he also did bad. What I'm not hearing is a clear understanding of how the parties want the court to sort it out when you've both acted in bad faith and broke the law related to the deposit.
Your Honor, as it relates to the deposit, I do want to say that during this time, I had already been notified by the city of Austin that this home was uninhabitable.
That doesn't matter, Ms. LeBron. The method to do that was different. You're not allowed to not use you can't just use the deposit, ever. There are methods to fix the situation. The way you chose to go about it is improper. Not that you wouldn't have been justified in seeking some resolution. The solution you sought was improper for the law and the lease. So is there any other evidence to support your counterclaim for damages? You've given me a lot of information. Anything else?
Yes, Your Honor. So on like I talked about on the last month's rent, my claim and my contention is that the last month's rent was not due to the City of Austin code and it being uninhabitable.
Ms. LeBron, highlight for me in this code department where you say they make it uninhabitable.
So on the first page, it says, after receipt of this notice and until compliance is attained, the City of Austin code prohibits the sale, lease, or transfer of this property.
Unless you provide the buyer a notice, but you've got the notice.
I got the notice on the 7th. That's when or sometime after.
Then Ms. LeBron, he's fine. It's not condemned. It's not. There are violations. And then in this, the violations highlighted track with some of the things that you've been complaining about all the way back since February. Your historical record of emails is more persuasive than anything else you've given me because it has that reliability to it, right? Well, when you moved in, did you find it? She did. And did you complain about it? She did. And did you complain about it? She did. Well, it must be true.
Right. And so
and then at the end, here is a lease, a complete uninterested third party that said, yep, some of those things still exist.
Yes,
but
Your Honor.
So my limit because he gave you notice. So he's sufficient for that. I'm not persuaded that you get out of October's rent. You stayed there, your stuff was in it.
Well, actually, I was moved out all of October, but I was cleaning. So my request, Your Honor, of the court is for October rent return for the full return of my security deposit ×3 because Mr. Alpert did not provide any item in his statement or return the deposit, the return of the $300 pet deposit. And I did ask for the loss of use and the rent. So
I got all that. All right. Now, Mr.
Thank you.
Alpert, again, if you have any particular questions that you'd like to ask of Ms. LeBron, go for it. But I
Sure.
understand what you're trying to caveat to, that some of these things she doesn't have photographic evidence of, but I would look
Well-
more at the historical record. She kept reminding you about it in emails. And I didn't see any emails where you said that's not true. So do you
Yeah,
have
but
any
you saw-
questions for Ms.
but you
LeBron
saw
that would
emails
help
where
me illustrate whether or not these charges are valid?
Well, so are we done with the part about we can't even show that the windows don't close? I was asking for evidence of that, any sort of evidence
All
that.
right, Ms.
windows don't
LeBron,
close.
did you have any photos that indicate the windows are unable to open or close?
I didn't submit them, Your Honor.
Okay,
Okay,
go ahead, Mr. Alpert.
you mentioned that the HOA had signaled code enforcement to come by. Did you meet with anyone from the HOA? Did they go inside to see all these things, or did you get any notifications from the HOA?
I think that's like 4 questions, Mr. Alpert.
I'll sum it up. Did you ever hear from the HOA about code compliance coming, Ms. LeBron?
No, it was an assumption because the HOA had recently been by the home. They have like a little truck and they drive out. I don't know if they sent him violations because they would have gone to
Ms.
him
LeBron,
directly.
why did you bring up the HOA? Is it just you surmising, or do you have any actual evidence to make you draw that conclusion?
I don't have evidence. It was
So it's an
just that they-
assumption. Great. You, Mr. Albert, move along. She's got no proof whatsoever the HOA got involved. Cool.
Okay, the missing cameras, do you know where the cameras were supposed to be that were missing?
throughout the home as marketed.
Any more specific?
I don't know, Mr. Alpert. It was your home. You marketed cameras throughout. You marketed smart appliances. You marketed smart switches. You marketed, I know that there was one on the exterior, both in the back and the front, and those were present, but the ones on the interior, when you and I had a conversation and we talked about your daughter and your daughter's bedroom, you talked about there's a camera in that room as a monitor. You talked about there was one in the master. You even went so
Okay,
far as
all right. I'm gonna jump through this for both of y'all. Can either of you point to a section in the lease that highlights where these cameras are supposed to be, or the number of cameras, or anything about the cameras at all? Is it in the lease? Yes or no? Mr. Alpert, is it in the lease that there's cameras?
Not in the lease.
Ms. LeBron, is there any spot in the lease that highlights this camera system supposed to be there?
No, Your Honor, he changed the lease.
Ms. LeBron, I got it. You said that. But you don't have a document that says that to prove to me that he changed it. So let me ask you this. Do you have any form of written communication, an ad, where they said there's cameras involved?
Yes, Your Honor. And I think that and I have more than what I submitted, but I think in what I submitted, Your Honor, that says, let me find it, mark text, hold on, let me go to it, Your Honor.
Sure.
He did slightly update the ad, but in mark text, it goes down to talk about price reduction, 2-story, 4-bedroom. It looks like it didn't all transmit. I apologize. I didn't realize that on the PDF, but it talks about smart double oven, smart cameras. It talks about
Cameras.
Wi-Fi.
All right, I found it. Let's all look at it together. Okay. Ms. LeBron, is this the ad that you're referring to?
Yes, and I'm sorry that it didn't transmit well in the PDF there.
What is this and where did you see this ad at?
Zillow.
This is the ad that you saw on Zillow.
Yes, and he did change it because there was a longer section on the cameras and smart homes, and it was like glittering.
Ms. LeBron, if you don't have it, it's not proof of anything. Right?
Yeah.
This is what you've got. So this is what I'm going with. Let's see if this covers anything. Price reduction. 1.5, I'm not sure what that means. 2-story, 4-bedroom bathhouse under trio canopies, new engineered wood flooring, ceramic tile bathrooms, recent window replacements.
That's when he replaced the windows after.
Commercial grade pan tilt zoom powered Ethernet surveillance cameras outside. Holy gosh. Commercial grade pan tilt zoom powered Ethernet surveillance cameras outside. smart plugs and switches, 2-zone air conditioning with Wi-Fi thermostats, 2 fireplaces, no carpet, outdoor theater with Cat 5 and 4-channel speaker setup, privacy fencing, walk-in closet, downstairs bar, smart double oven that can be controlled with a handheld device. Do we need to do that? You know, I don't cook, so maybe for other people. Good for y'all. Ceiling
exists,
fans,
Your
family
Honor.
bedrooms, breakfast nook, side entry, 2-car garage, built, I don't know what built-in stumps, MyQ, remote access, garage door openers, 2 openers, and so much more.
Remote, that's part of the smart home, Your Honor, and none of that ever existed.
All right, Mr. Alpert, do you recognize this ad?
Yes,
Is this a correct ad for the house?
it is.
All right, so there were supposed to be outdoor cameras, this commercial pan tilt, that just sounds very exciting. It does, y'all. I finally got one of those Ring doorbells, and I never knew how excited I could be to see the Amazon drop something off. Like, ooh, look. And you know, scare my husband. Hey,
Right.
sweep. I see leaves. Okay, but outdoor cameras.
Whole theater system and sound system and speakers and MyQ remote. I mean, he markets all of these things. None of it existed, Your Honor.
I get you. All right. Did you tour the property before you signed the lease?
Yes, Your Honor.
Did you notice any of those things missing?
No, Your Honor. When I toured the property, he had painting done after I toured the property too.
Okay.
So
So
I
he-
improved it after you saw it?
I mean, are you confused?
Y'all, I would encourage y'all both to just stay quiet, right? You're not winning any parts with something like that. Okay. So,
Okay, there
what
was a
other
men-
questions, Mr. Alpert? We asked her about the windows. She brought us forth the ad to indicate that that's why she believed there would be cameras and outdoor theater and smart home system set up in it because it was in the ad for it. All right. What other questions do you have for Ms. LeBron?
You mentioned there was mold around the front door. Do you have any pictures of that?
I did submit pictures of that, but it looks like some of my submission on the PDF didn't go through. But it was, the door was also one of the things cited by Austin Code.
Okay, do you want to bring that up, what the problem was with the front door? Did it say in code enforcement that it doesn't close and it doesn't lock?
I'm not sure exactly what it said, Mr. Alpert. I believe you have
Let's
the.
take a look. Let's take a look, y'all. Here it is. First page was structural maintenance, smoke alarms, carbon monoxide smoke alarms. Bottom panel of the kitchen cabinet is deteriorated, so that's not the front door.
It
Second
also
floor
said it in my
ceiling, stairs and threshold, interior doors, electrical outlets, random cords and wires hanging around. Main entrance door. Here it is. Let's see what it says, okay? The main entrance door, side light, frame, jamb, mole cover, and mole post have deteriorated, causing the door frame to move when opening, which is much what she said happened to her. All exterior doors, assemblies, if provided, should be maintained in good condition. Locks at entrances should be tightly secure the door. So Austin Code found an issue with the main entrance door not properly working.
Well, what it's saying, Your Honor, is that the mole
door frame
post
moves.
and the jamb is deteriorating, but it's still a door that, yes, we took
Mr.
care of that,
Alpert,
but I
you're-
don't want that to be understood that it's not closing and it's not locking and it's not securing anybody.
Okay.
I also included it in my emails, Your Honor, the door's not closing in multiple of the emails that we entered into evidence.
Yeah, okay. What other questions, Mr. Alpert? But the code compliance does mention the front door.
Okay, so you said the garage doors don't open, and I see a picture of one garage door where it looks like a wheel came off. There's another garage door. Do you have any pictures that doesn't open?
I have the emails that I sent to you. I don't know what all pictures transmitted in my evidence, but I have the emails about the garage doors.
Okay. Do you recall Dwayne asking you when he can come by to do the work?
Well, he asked when he could come by and look at that bathroom again. And then we had multiple exchanges after that because that was in February.
Well,
We
what
had
kind of exchanges are you referring to?
all of the emails submitted into evidence, Mr. Alpert.
Mr. Alpert, do you have proof that you had the garage door repaired?
So I didn't send it to you, but Inspector Paterno has cleared this whole thing, so it's all cleared. But I can send it to you, but
No, I mean,
that wasn't the scope of my suit.
it's not. So what I'm getting at here, y'all, is that, again, I see a lot of information from both. In terms of your case to her, though, it's definitely about her not paying. And her
Right.
case to you is about you not repairing certain things,
Right.
right? So in order to overcome her establishing a record of proof here, do you have any evidence that would contradict her statements? Like, is this a repair receipt from Dwayne when he came out and fixed that? Isn't it true
Well,
that on this date, I sent out
Yeah.
this service to fix that? Those would
Okay,
be a
so
more
if we
persuasive
can-
way of asking her questions to overcome what she's
Yes.
not in her burden, okay?
Yes, Your Honor. But there's an exhibit, one of my pages that I noted is page 10. So it's in that first. I want to ask if she recognizes an email that references.
What is the exhibit, sir?
So it would be in that first one that says 1 to 25, and it's, if you'll scroll till you hit page 10.
This May 7th email?
Oh, I'm sorry, that's hers. So go to 11. Wait, I'm sorry, hold on, give me a second. Okay, so page 11, the last 3 lines.
All right, so let me
Is that from
show
her?
you what I'm looking at.
Yeah,
Okay.
yeah, page
Mr. Albert,
11.
this is, but page 11 is a continuation of what begins here. So on May 7th, 2022 at 10:42 a.m.
Yes.
Mark Alpert wrote, and then this is the message. Zoom it so we can read
Your
it.
Honor, I'm going to object to this. There's random writing all over it. This is,
Ms. LeBron, I will ignore all of those things to the side because those are superfluous. I don't disagree. But the email communication is what I'm looking at, okay, for the historic record. That's a great point. And we absolutely will ignore any of those comments there because that's just people writing things down and that's not evidence of something. This, though, he says, is an email that was sent to you on or about May 7th at 10:42 a.m. And it says, "Hi, Leanne and Chris. We're at a point where an enforcement may be imminent. That said, Chris is a tenant and it's required that all the tenants be notified. I lived in that home for 10 years. I don't have an electrical problem. Dwayne fixed the sticky diverted at upstairs hall bath.
I meant to be diverter.
He showed you the fix and you acknowledged it was working fine. I had Dwayne go out there to see what you need and you turned him away. He followed up and you ignored him. I too followed up and you got upset with me."
Do you recall that email?
I do, and I replied to it and I said, none of that is true.
So Dwayne did not go out. Dwayne did not put WD-40, pull off the existing diverter, lube it, put it back on, and then show you that it was working.
No,
That didn't
I
happen?
didn't. It's addressed in the email that's already been submitted into evidence and testified to.
Were you aware he was on the phone while he was in there, in your place? Did you notice he was on the phone?
As I testified, he brought an old bathroom or a sink.
I'm asking you if you were aware he was on the phone. Were you aware he was talking to me while he was working?
Let her answer the question, Mr. Alpert.
He was not on the phone because he was speaking to me. I replied to that email and I said, none of this is true. It didn't happen. It still needs to be repaired. He wasn't able to repair it.
Okay, let's move this along,
Okay.
Mr. Alpert. Do you
Page
have proof of
12,
a
go to
repair
page-
made? Because that would be more persuasive than asking her to remember a conversation.
Okay, page 12.
This is a screenshot. Mr. Alpert, what is this a screenshot of?
This is a message it doesn't go higher. It says Leanne H. February 17th above where it says should. Yeah, there we go.
Is this, what is this though? Is this a screenshot from your phone, from someone else's phone?
It's her email that I sent as a clip. So do you recall this portion of an email on February 17th from you to me?
I do. I don't know about the text message. What I do know is that my daughter was hospitalized and you were harassing me via text and email and calls. And I
Okay.
said, this was one instance in February where you just repeated back to back as calling me and harassing me. I said, hey, we're in the hospital. My daughter's in the hospital. So that's what that was about. And then I followed up multiple times after that, including March, April, May, asking for the repair request.
So I just see one message. What were the dates that you're saying you were harassed? How frequently was this? What were the dates?
No one was harassed. Move along.
Okay. So what did
You're
you mean by
harassing the judge with this unnecessary set of questions to establish for me that you illegally kept her deposit and didn't itemize it. Mr. Alpert, let me say right now.
This is about the counterclaim
you-
more than.
I know, and she's met her burden on the counterclaim more than you met your burden on the initial claim. Right now, in my mind, I'm awarding treble damages to her.
But you're
full amount of the deposit.
you're a believer that I didn't attempt to address her repairs, and that's
No,
what
it
this
has
page 12
nothing to,
was.
I got nothing to do with the repairs. I'm not ignoring, I'm entirely leaving that out. Solely on the legal issue of you failing to send her an itemization, you lost, right?
Yeah.
A very
Yeah.
simple way to come down to this. End of
Okay.
story, no
Okay.
exception. Neither
all right,
of you have come up
all
with
right.
any persuasive evidence otherwise. So that's what we're going with, okay?
Okay, if you're
no-
fine with the repairs. then-
Judgment for the defendant on the counterclaim. Plaintiff take nothing on their original claim.
Oh, wait, Your Honor, you're
No,
already
I'm-
judging.
Yes.
But
No,
I get.
I don't, Mr. Alpert. Listen to what I'm
Your
saying.
Honor, there's a very important one you haven't let me do. You would need to see what there's a piece of
Mr.
evidence.
Alpert, as a matter of law.
And I'm not done cross-examining
already-
her. I'm not.
If you keep
I'm not
over
done
talking me, I'm
cross-examining
gonna
her.
hold you in contempt and fine you.
I don't want that.
Listen
but
to
Your
the
Honor,
answer I'm giving you. As
Your
a
Honor.
matter of law, you dropped the ball.
But Your Honor, there's a prior
If
case. She's
you-
doing the same thing to somebody
Mr.
else
Alpert,
right
it doesn't
now.
matter. I'm gonna hold you in
It's
contempt.
all made up.
Okay.
It's a bunch of
A
lies.
$100 fine for direct contempt. I have instructed you twice to be quiet and you have continued to persist in speaking over me. $100 fine for the plaintiff. Mr. Alpert, I'm going to be very clear. The absolute clear line in this case is the legal duty of the landlord to itemize or return a deposit. In your own testimony, you acknowledge straight up that you failed to return her pet deposit.
The remainder
did.
of the pet deposit.
You did. You can't keep it. You also
Okay,
failed
that doesn't-
entirely to itemize.
I
What you
understand.
should have done
$900.
is send her a letter, and you didn't do that. So as a result, plaintiff will take nothing on their claim, and to the counterclaim, I will award back your $20.50, and that's it. $20.50 to the defendant. I'm not going to award treble because both of you acted in bad faith.
So
But
I'm
there's
paying
a
her
bright
$20.50?
line law, Mr. Alpert, you're not helping. There's a bright line law in the property code that a landlord has an absolute automatic duty to refund or itemize. She gave you an address, she moved out, you didn't do that. You can't keep the money, but I'm not going to treble it because Ms. LeBron, you also broke the law and the lease. So that's it. $100 contempt fine for the plaintiff for direct contempt, $20.50 to the defendant on their counterclaim. All parties are free to appeal that decision. All right.
There's the $300 pet deposit. I'm sorry.
I'm giving, all right, you're right. You get back the pet deposit because you paid that extra. $23.50 is the judgment to the defendant. All parties are excused.
Your Honor, there was the $120
I'm
for
giving
the.
you $23.50.
Thank you, Your Honor.
You can appeal if you want that $120, okay? Y'all
Thank
have a
you, Your
nice day.
Honor. Have a
Thank
good day.
you.
Thank you. Thank you.
Follow the law for both sides.
Thank you.
For
Thank
both
you.
sides.
Thank you, Your Honor.
Jamie, let's take a look at our docket because we've had many patient parties with us and we are not going to be able to get to in-air contested matters today. So for parties in which we had all parties present, that would be number 1732 and 0061649. For those matters.
Did you guys like that ending there? I think that ended up being pretty epic by Judge Y'all. That is definitely her name. She is Judge Y'all. That was a great stream. Thank you so much for everybody being here. I really appreciate all of your time and your clicks of buttons, like likes, and yeah, all the fun that we've had in the chat. I really appreciate it. I literally have to clean my whole house. I have to. So I really probably should get going. But I hope you all have a wonderful evening tonight. I hope you all wake up to wonderful things and we'll all have a great day in court tomorrow. And I appreciate every single one of you liking, commenting, subscribing, giving me ideas, encouragement, and just coming along and watching court in my kitchen because it's fun. So, anyways, guys, thank you so much again. I really appreciate it. Oh, you know what's funny? Wait, let me try an outro, okay? Let's see if you guys like this. Well, that's all from the kitchen court cases today. We hope you enjoyed our verdicts and recipes. However, we need to get this tape off the air. So this kitchen is now closed to the public. Please allow 20 seconds for the tape to burn off. Don't forget to subscribe and hit the notification bell. And we'll see you next time on Kitchen Court Cases.